mixed use and industrial, hazardous substances and contaminated land. We had a pretty full day yesterday, and we'll proceed with the remainder of the submitters who wish to be heard, starting with Ms. Whitney on behalf of Transpower. So is Ms. Whitney there? Good morning, Ms. Whitney and Mr. Hamilton.
Good morning.
Morning. Thank you for your evidence. Presume you can hear us okay?
Can you hear us?
Yes, no, that's perfect. We've received your evidence, and this morning we've received your additional speaking notes, Ms. Whitney. So how do you want to proceed?
If agreeable to the panel, I'll just run briefly through my speaking notes. They just kind of highlight the main points of my evidence and just respond to a couple of the points of the rebuttal evidence of the Section 42A officer. It should only take a couple of minutes. And obviously I do note I'm joined by Mr. Daniel Hamilton. Mr. Hamilton's the strategic planning lead at Transpower. Hasn't provided any evidence or lodged any, just really here to answer any questions the panel may have.
Thank you. That's ideal. Thank you.
Thank you. So just for the record, my name is Pauline Whitney and I'm a planner at Balfour School. So my evidence only related to one submission point to be addressed at this hearing, and that related to the topic of reverse sensitivity. I've already introduced Mr. Hamilton. So in terms of the relevance of the definition to the national grid, given the requirement in Policy 11 of the National Policy Statement for Electricity Networks 2008, and obviously amended late last year, Policy 11 requires to avoid reverse sensitivity effects on the electricity network to the extent reasonably possible. And obviously within the Hutt City proposed district plan, there's policy PINFP3, which has a specific policy relating to the protection of infrastructure. So those were included in my evidence as well, and I've included in footnotes and speaking notes. So Transpower essentially sought the notified definition of reverse sensitivity be replaced by the simplified wording, reflecting that within the Greater Wellington Regional Council RPS. This would not only provide consistency with the definition used in the proposed Wellington City District Plan, and I note that definition there was appealed and amended under consent order in April last year to reflect the RPS definition, but it also would be consistent with that used in the Porirua District Plan, which was made operative late last year. Even probably more importantly, the use of the RPS definition, in my opinion, would ensure the use of a definition that is, I understand, is based on best practice, has been informed by case law and is well understood. If I can just comment in terms of the age of the definition in the RPS, I know the RPS was made operative in 2013. I do note that despite the definition featuring in an amended policy in the RPS Plan Change 1, and that's policy 32, the RPS definition itself was not amended. And so in my opinion, this reflects the definition was considered almost fit for purpose at the time of that plan change, that recent plan change. While I do not wish to stray into case law as I am not a lawyer, in addition to the Wellington City Council proposed district plan appeal, which I mentioned earlier, I'm also aware of two other recent Environment Court cases where agreement was reached through court mediation and consent orders on a definition of reverse sensitivity. And again, these kind of reflect the direction of the RPS, the Greater Wellington RPS definition that I support. I've referenced those two cases below in footnotes, and just noting that I was directly involved for Transpower in the New Plymouth case. So I've reviewed the officer's rebuttal evidence and note his recommendation to retain the definition as provided in the Section 42A report. Mr. Davies and I appear to have a difference in opinion on the most appropriate definition to adopt, and my evidence stands. And I've just got a couple of really brief bullet points I'd just like to comment on. While there's no national planning standards definition, there is consistency across the region and nationwide, and I do not consider the matter of consistency to be purely one of convenience for plan users. Rather, the consistency reflects a concept that's evolved and been tested through case law. And in my opinion, the Section 42A report recommendation introduces untested elements. Finally, Mr. Davies has also commented on how the definition is used within the plan objectives and policies and matters of discretion. And as I understand from reading his evidence and rebuttal evidence, the definition as framed by Mr. Davies appropriately sets the limits on how the concept is applied, not the specific plan provisions. So I disagree with that approach, particularly given the wide use of the definition throughout the plan. As outlined in my evidence, the Section 42A report definition, in my opinion, does not give effect to the NPSEN. Instead, the definition is framed as such that reverse sensitivity effects may not even be a relevant policy consideration under the tests contained with the definition. And I fully accept that a revised definition would require plan provisions to be revisited in terms of how the definition is dressed within a specific policy context. But in my opinion, that approach is preferred rather than relying on an untested and, in my opinion, a potentially problematic definition. So that essentially sums up my evidence and my position to date. So happy to take any questions the panel may have.
Thank you, Ms. Whitney. I'll just ask my colleagues. Commissioner Jones.
Good morning, Ms. Whitney. Thank you for your evidence and for this helpful summary. I just had one question, and it relates to your last paragraph and the very end of that. And I was just going to draw your attention, if you didn't sit through yesterday, to that point you made about Mr. Davis advising the panel that consequential changes may be needed in the plan if the definition's changed. Have you turned your mind to what those may entail?
I did a quick look this morning. In terms of the national grid, there's probably only two policies which are relevant. One is that PINFP3, and then there's one in the subdivision chapter. In my opinion, the way the RPS definition would still fit within the context of how the term is used within those policies. And I'm also mindful that they will be looked at in future chapters, so there is the opportunity to look at them and examine any altered definition in that context. I guess my concern at the moment is the way the definition's framed in the 42A report. It's potentially the effects on Transpower's activities, for example, may not even be considered reverse sensitivity, and therefore those policies may not even come into play. So
yes. Okay, so just so I've got that right, those two policies that you've identified at face value don't appear to need revisiting, but should you look more closely at that in readiness for future hearings, it can be addressed at that time.
Yes. Yeah, I'm also mindful, obviously, since the plan was notified, the NPS electricity networks has been changed, so there might need to be some refinement of wording anyway. So
yes. That's very helpful. So the panel might look forward to hearing from you.
Yes, certainly.
In coming months. Thank you.
But if I can just comment briefly as well, in my experience on the other more uniform definition that's applied in other plans, a similar approach to in PINFP3, a similar policy approach has been suitable. So I don't see it as entirely problematic or radical redrafting would be required.
Okay, that's helpful. One other thing I'll just signal now, if you didn't tune in to the first hearing stream, we did have legal submissions from Mr. Quinn for the council.
Right.
He's given us advice on the new national direction. And I think it's fair to say he's urged us to take a precautionary approach in implementing new direction unless there's valid scope in submissions and unless it's unaffected by the plan stop, and also, of course, to consider natural justice matters. So just so you're aware of the advice that's before the panel, that might help you consider your future evidence preparations.
No, I have read that advice, thank you, and it is top of mind. So,
Thank you, Ms. Whitney.
thank you.
David?
Good morning, Ms. Whitney. Commissioner McMahon here. Just a couple of minor ones for me. Of those two policies that you identified off the cuff, can you remember what the subdivision one was out of?
It is referenced in my evidence, and I will find it for you. SUB P25,
Thank you.
clause 2.
Clause 2. Thank you. Secondly, and drawing on the clarification that Commissioner Jones just made regarding new national direction, is there anything in the suite of new policy direction that arrived in mid-January that that you think we need to be aware of, particularly the MPSI, that would assist in this matter, or does that not touch on this sort of detail?
In a general sense, one issue I'm grappling with in my head is the relationship to overlays. That's a wider issue in terms of references within the amended MPS, particularly in Policy 6, without going into too much detail. So the relationship to overlays, yeah.
Okay, and presumably that'll come up in another hearing stream anyway, but nothing in relation to reverse sensitivity?
No, nothing. I mean, the policy in the MPS EN is to avoid reverse sensitivity effects where practicable from memory. It's in Policy 11. If it's helpful, I can just refer quickly to the wording in the old MPS, as I'll call it.
And it is reasonably old too.
It is reasonably old as well.
I was just thinking, I think the NPSI transfer has a carve out from that, doesn't it, Pauline? So I don't think that would be relevant.
Yeah, no, so I'm talking about
so
the
just-
MPS
yeah.
ET.
ET.
The ET, so, yeah. It was Policy 10.
Yeah.
Must, to the extent reasonably possible, manage activities to avoid reverse sensitivity effects. So it's very similar to the new Policy 11 in the MPS EN. So with an avoid directive, reverse sensitivity to the extent possible. So they're very much aligned, so I don't see an issue with that.
Okay. Final question. Thank you for that. Final question from me is just in your paragraph 1.5 of your summary statement, you talked about the context about the amended policy in RPS Plan Change 1. And
Yes.
You made the point that the RPS definition wasn't amended, just the policy. Was the definition up for grabs in terms of being on the plan? And if so, were there any submissions on the definition on RPS PC1?
No, there was not. It was not up for grabs and therefore no submissions. But I guess the point I just wanted to make in that is, given that policy was reworked and added to, and reverse sensitivity was specifically referenced in that policy through Plan Change 1, I would have thought that the officers would have looked at that definition when they were drafting that policy and plan change to see whether it still fit the purpose.
Thank you. That was all from me. Appreciate that.
And nothing further from me either. Thank you both for your attendance this morning.
Thank you very much.
And, yeah, thanks
See
for
you.
letting us join online as well. It's it's not always ideal, but we appreciate the flexibility there.
Very good. Not a problem. Okay.
Okay, thank
Thank
you.
you. Have a good day. Bye.
Now we have, the next submitter is Ms. Rossa, Enviro NZ Services Limited. Is she online? She is. Good. Are you there, Ms. Rossa?
Yes, here we are.
Kia ora, good morning. Thank you for your attendance this morning. We have your evidence, and I presume you'd just like to give us a brief overview of that first before we go into questions, or would you prefer to go straight into questions?
Yeah, well, I guess in that sense, just a brief overview in relation to saying who Enviro NZ is and in my role in that, and just I guess the main thrust of the submission points that were provided. So my name is Karen Rossa, and I am the planner in-house for Enviro NZ, which is a national provider of waste management infrastructure. Enviro NZ operates throughout the country with over 60 sites under management, and it operates in Hutt City and has collection and recycling services from a site in Gracefield. Waste management is an essential infrastructure, and often it's forgotten about, and it works in the background to make sure that we have clean streets, homes and businesses, but solid waste is a significant contributor to unsustainable development and climate change, and so reducing waste through a circular economy is necessary to reduce the impacts of solid waste production, but to enable a recircular economy, waste must be separated, hopefully mostly on site, then collected and sorted and processed for reuse of constituent materials. As waste management specialists and operators of transfer stations, recycling facilities and landfills, the continued operation and diversification of these facilities is necessary to achieve a circular economy. So therefore, district plans are important documents to ensure that this ongoing process is appropriately provided for. So with respect to this hearing stream, there's a few points, but I guess the main issues come up under the industrial zones. So nearly all waste facilities are located in industrial zones, urban waste facilities, obviously not landfills. Given the nature of aggregating waste for either disposal or recycling, industrial zones are therefore important to ensure that waste infrastructure and facilities can operate and do so efficiently. So the overall thrust of the submission points outstanding is to really tighten the objectives and policies of these industrial zones to favour the prime activity being industrial. And I guess, without going into sort of, I guess, probably if I understand there obviously might be a few questions, so I'll just make a relevant comment in relation to the Wairarapa Wellington Horowhenua Industrial Land Supply document. This was, I guess, put out in 2025, and it's a relevant document to the discussion because it shows there's a current and future shortfall of industrial land in the Wellington region. And one of its recommendations is that existing supply should be safeguarded. So I guess just ensuring that the tests for particularly non-industrial activities are robust enough would help achieve that recommendation. And I guess just the only other thing on that in relation to that is that that report does specify that there's, I think it's 524 hectares of industrial land in the Hutt. It's obviously the biggest contiguous area. in the Wellington region, and only 16 hectares of that were vacant. So on that note, I'll leave you to ask some questions.
All right, thank you, Ms. Rosser. Matt?
Morning, Ms. Rosser. Thank you for that. Commissioner Muspratt here. I just have one question in regards to paragraph 6.16 of your evidence. This is the part where you're requesting a change to insert the word adverse into the objective.
Yes. Yes, so I have changed, having read some of the other evidence in relation to the qualifier unreasonable reverse sensitivity effects. I think I do prefer to support Georgina McPherson's evidence on that. So I would basically, I guess in this particular sense for this heavy industrial zone, prefer no qualifier.
Okay, thank you.
Am I right? Jason?
Good morning, Ms. Rosser. Thank you for your evidence. It's Commissioner Jones here. I found your evidence to be very clear. I understand where you have aligned yourself with the officer and where you still have a difference of opinion. So thank you for clearly articulating that. I'm looking at paragraph 4.6 of your evidence. And this is in the context of your discussion about co-location benefits and trip chaining in particular.
Yes.
And I was just wondering, in the context of paragraph 4.6, you've suggested that an alternative would be worth considering, but I couldn't see if you'd proposed your own drafting solution in that respect.
I mean, originally in the submission, I think we had trip length and coordination. I guess in relation to the actual meaning of trip chaining, that perhaps trip coordination might work a bit better.
So referring
but
back
there
to the
could be
submission.
other. Yeah, well, there could be other solutions there, but
Okay, well, is that
yeah.
something you might be able to come back to the panel on?
I guess I could have a better thought on that. Yes.
Yeah, appreciate that you may just ultimately land on what was specified in the submission notice, but now that you have the benefit of Mr. Davis's 42A report and his rebuttal, if you have any other solutions that you'd like to put before the panel, we'd be interested to hear those. And I think we've asked for some homework of some parties yesterday, and we've just asked if perhaps you could come back to us next week. That would be consistent with what we agreed with others yesterday.
Yep, that's no problem.
Thank you. That's all from me. Thanks again for your evidence.
I don't have any questions myself either, but you mentioned that you preferred the evidence of Ms. McPherson in relation to HIZ02. If you're coming back to us anyway, can you just confirm that in writing, that that is your position? That will be helpful to us as well.
Yep, no problem.
Great. Thank you for that, Ms. Rosser. We have no further questions, and thank you for your evidence and the time that you put into it.
Thank you for your consideration.
Next week. Oh, Ms. Rosser, if you're still there, just in terms of the time frame, if we can have something back from you perhaps next week, that will be beneficial to us. Thank you.
Thank you.
Right, the next submitter we have is the fuel companies and Z Energy. Do you have a team here, do we? Jolly good, welcome.
Yes, morning. Just checking if you can hear me first.
Yes, that's fine. That's Mr.
Thank you.
Enright.
Yes, good morning.
Good morning.
And we have a team partly online, partly in person, and naturally appreciate the online option. So as you noted, I'm counsel for the fuel companies and their submissions today.
Yes.
Also online, we have Ms. Pollich, who's based in Sydney, and I think hopefully she's on screen. Could we just check she can hear us? Jenny, can you hear us?
I think you're on mute, Ms. Pollich.
We might just need to make sure that Ms. Pollich can hear us, Sir, before we sort of kick off, unless she can show us. I can't see this.
Can you hear me now?
Great, thank you.
We can
Sorry,
hear
I just
you.
had to swap some settings.
Thank you. That's
All
great.
right, very good.
And of course, in person, we have Matt Tinley, who's the Engineering Manager and Technical Authority for Z Energy Limited on a New Zealand-wide basis, and the Planning Consultant, Georgina McPherson. So just a housekeeping matter, we just want to make sure you have received, and if the panel has had time to read Mr. Tinley's evidence that was only circulated yesterday.
Well, we received it last night.
Yes.
I have to say, from my own personal view, I have scanned it. I haven't
Yes.
completely absorbed it as I would normally want to.
Certainly.
It was very late in the piece. We'd started the hearing yesterday and we received it last night. So is this more in the way of corporate assistance, or is it a statement of evidence?
Well, first,
I had a chance to look at it either.
yes. So first, we do apologise for the lateness of the evidence. It is intended to be evidence, and one of the factors that does arise from the planning instruments is that the lens applied by the operator is critical to understanding what the infrastructure needs are here. In this case, for the bulk storage terminals and the wharf line, and so we felt it'll be of greater assistance to the panel to hear direct from the operator rather than simply through the evaluative evidence of Ms. McPherson or our technical expert, Ms. Pollich. So it's intended to assist the panel, and certainly we're happy to, I'm sure Mr. Tinley can speak to it and give you some of the key high points from that evidence. One of the attachments to his evidence, you may have noted, we picked up a question yesterday from the panel about exploring, obviously, whether it's feasible to have more than one overlay in a plan subject to a merits assessment. And for that reason, Mr. Tinley included, just for you, one example where that very approach has been taken, where there are two contours. So we were trying to, again, assist the panel.
Thank you, Mr. Enright. It is useful material to us. Don't get me wrong, it is useful material to us. I guess a little just a bit concerned that none of the other parties have had the opportunity to assess it prior to giving their own evidence either. So that's the dilemma we have. But at the end of the day, it's probably not a problem, because I signalled yesterday that in terms of your evidence and the matters raised in the fuel company's evidence, as well as the marina evidence as well, we are contemplating directing conferencing, and that's been welcomed by you and your clients as the correct approach. We will be looking to formalise a minute, probably looking to get it out early next week. So just to let you know before you start that that is our current approach that we are thinking. It will be very useful to us.
Thank you, and we are grateful. We did listen in yesterday to the first session in particular, and were pleased to hear the panel is contemplating caucusing. It's particularly material to the technical evidence where, although there's currently a gulf in recommendation between Ms. Pollich and Mr. Munkoff, if they have that opportunity to caucus, hopefully that will assist the panel better in terms of that technical dispute around best contour and how to manage particularly the wharf line. So as you say, Mr. Chair, we're supportive of that. Again, do apologise for any inconvenience. It is intended as a corporate evidence, so it wasn't intended as an expert brief, obviously. But anyway, I'll move on from that. But
we accept that, and the offer of making your people available. It's from our perspective. It's not only the actual technical hazardous substances. It's the way it's actually reflected in the plan framework, which is hugely important as well. So I'll just say that at the moment. Perhaps instead of me talking, perhaps we'll get you to.
Thank you. Just totally understood that at the end of the day, we're here to address you on the wording of the plan, and to some extent that's reliant on the technical evidence, but obviously the planning evidence is critical to that. We have essentially three positions being put forward by key submitters here, including the 42A officer plus the marina and the fuel companies have slightly divergent, as you know, positions. So I'll just briefly speak. We're taking, apart from the issue with Mr. Tinley's evidence having come in late, we are taking our submissions and evidence as read. I will just briefly speak to my legal submissions, and I did hear there were some questions likely to come my way on the MPSI, which I would, of course, invite and welcome. I just wanted to say as a preliminary matter that at the time I prepared my legal submissions, I wasn't aware of Mr. Quinn's legal opinion on the your duty to give effect to national direction instruments that were notified or became operative after the PDP itself was notified in the context of this decision-making process. So I've now had an opportunity. Mr. Quinn's opinion was in, I think, hearing stream 1. So unfortunately, it took Ms. McPherson to track it down for me, for which I was grateful. But the gist of Mr. Quinn's position I agree with, which is that the hearings panel does have a duty to give effect to the new national direction instruments, but solely to the extent that there is scope to do so. And it was an important concession yesterday from Mr. Wesley, in answer to questions from the panel, where he agreed there was no real question of scope arising in terms of Policies Act 9 and 10 of the MPSI, in terms of the relief sought by the fuel companies. So at the high level, the submission here is that you do have to give effect to the MPSI within scope. And what the key point that I submitted here is that it goes to the question of planning assessment, planning weight. So the MPSI very plainly puts greater weight, emphasis on resilience of infrastructure as distinct from the position of here, the marina, as a, in terms of its future aspirations. And there is also a focus on both existing and future minor or major upgrades. So it's really kind of, my submission has shifted the balance that you have to apply what becomes more important, what becomes less important when you're looking at the words, bearing in mind there is scope to implement the changes that Ms. McPherson has recommended. And my written submissions, as you know, have focused on the directive language used in the instrument, such as the words enable and not compromise. One of the questions that came up yesterday related to the whether to read each policy individually or read the instrument as a whole, with particular reference to Policies Act 9 and 10. And my submission on that is that, of course, you have to read the instrument as a whole. You can't sort of cherry pick a policy out. But when one looks at the wording of the instrument, Policy 10 is a particular moment here because it references decision makers on planning instruments. So it's obviously particularly directed at the PDP process we're faced with here. as relevant, and then obviously sets out methods to be applied through the district plan, odds polls and methods rules, including buffers, for example. And there's some quite important language in there relating to both the dual focus, not only on managing risk, but also on managing incompatible activities. And you'll note, and I did provide the panel with a copy just to assist you, but the instrument, for example, in policy 10(2)(a)(2) refers to both sensitive and incompatible activities. So it's not just a single focus on sensitive activities, also in the language of the instrument also refers to those activities which are incompatible. So we've sort of placed some reliance on that, obviously, as relevant to the question of priority, giving priority to the resilience of the bulk storage terminals and the wharf line, and not only existing but potential upgrades. That's the language in the instrument. And so we've suggested, and obviously the panel's considering, that it might be appropriate for plan caucusing on the extent to which the chapters, the two relevant chapters, hazardous substances and the Seaview Marina, give effect to this instrument within scope of the submissions would be, we say, a helpful question to address. I do need to point out to you that because we are relying ourselves on the fact that the Seaview Marina is not infrastructure as defined by Section 2 RMA, I do need to point out to you that Section 2 RMA, the definition of infrastructure in terms of fuel infrastructure, refers to pipelines rather than the BSTs, the bulk storage terminals. And we say that the bulk storage terminals are, however, captured by two things. One, the definition of regionally significant infrastructure in the RPS, which specifically refers to terminals, and also the NPSI, which refers to both infrastructure as defined by Section 2, and there are numerous references to supporting infrastructure, which we say would include necessarily the terminals themselves. So I did want to make that point explicit to you, but we say on any reading of the NPSI, it does apply both to the terminals and the wharf line, and it would be a very strange reading to not address the bulk storage terminals as part of that infrastructure. So I have probably captured most of my high-level points, but one thing just to draw to your attention, and it applies particularly to the question of the wharf lines, where, again, we say it would certainly benefit from further caucusing, is that there seems to be a common view that there should be some measure of protection for the wharf lines, but the suggestion is made by, I think, Ms. Blackwell in her rebuttal evidence, that it's too late now. There's no QRA for the wharf lines, so it's too late to have some sort of corridor in place to protect those wharf lines. And we submit that's an untenable planning position to adopt. We know there's a need to protect the wharf line corridors. Now is the opportunity to do so. There's greater emphasis given to the wharf lines via the NPSI. And although in the ideal world you might have a 2026 QRA for the wharf lines, we still have more than sufficient technical evidence to support protecting those the wharf line and the adjacent corridor from intrusive activity or incompatible activity. So we do want to just sort of emphasise it is important to deal with that, and you don't need a perfect state of knowledge. You have sufficient technical backup from Ms. Pollich and her evidence to include provisions within scope of the fuel company submissions. So those are that's a high-level summary for you. I'm very happy to take questions either now or later. Thank you.
Probably now, I think. David?
Good morning, Mr. Enright. Can you hear me okay?
Yes, thank you, I can.
Yes, Commissioner McMahon here. Thank you for your legal submissions and your very precise summary this morning. That I found that to be very useful. And also thank you for listening in yesterday and acknowledging that there were some questions in relation to some of the national direction matters. And from my perspective, you've answered most of those in your opening verbal presentation. I just got one residual question to you, and it relates to the test under Section 75 of giving effect to the MPS. And it's quite clear that planning instruments need to do that, and obviously within the codicil of being within scope. My question relates to the other codicil, if you like, and that's the time frame for doing so. And I think the wording is something like as soon as possible or as soon as practicable. Is that your understanding of the?
Look, I'm just bringing up Section 75, as I don't want to put you wrong on this. And as you know, I think it's Section 75 bracket 3, which relevantly states a district plan must give effect to brackets brackets B, a national, no, it must be national policy statement A.
Yes.
So the timing for which is really a matter Mr. Quinn addressed quite comprehensively in his legal opinion. And as you know, and again, I think you, sir, were the commissioner that raised this point yesterday, that the NPSI itself, helpfully from my perspective perhaps, but in its full 3.1 timing says that you must give effect to the NPS on and from the commencement date. So it hasn't given a transitional process,
No.
As you know, and so my submission is really that Mr. Quinn's addressed this effectively in his opinion, that you should do so both for the NPSI and other relevant national direction instruments for the purposes of your decisions, but again, only within the constraints of scope. Because as Mr. Quinn pointed out, scope is very important to fairness. And, you know, we couldn't come in here and ask for totally new provisions that weren't in our submission points, for example, just because the NPSI is, as we say, directive. That would be unfair to other parties. But certainly because we've got scope, we say this gives another quite important weighting that does apply from now and not down the track. A reason to give greater weighting to the fuel company submissions, essentially.
Okay. I don't want to make too much of an issue of it, Mr. Enright. I think we're on the same page, but just for the record, I think a couple of the MPSs are time-stamped in terms of when that, and I think the MPSIB is an example of that, whereas the MPSI, and it may well be in the MPS itself, where it says, uses the terms as soon as possible or as soon as practicable.
Look, I agree with you, and if the NPSI was qualified in that manner, like some of the other instruments, then I'd have a harder job, I suspect, of persuading you to give it greater weight, planning weight now, not later. But yes, it is in that other category where I can submit that.
Yes. So just to wrap this up, this is not a situation where anyone wants to kick the can down the road. It's there's some national direction that is captured by the scope of submissions, and your position is that it should be dealt with now, not in some future planning instrument.
Yes, so that's correct. Within scope of the submissions before you, correct.
Yes. Thank you for that. And just one final matter. Thank you. I don't want to revisit this, but on the matter of Mr. Tinley's evidence, just for the record, because I was a little bit confused when I read that, because it was stated, it was headed up a statement, and but in the evidence itself, Mr. Tinley refers to the term evidence, yet he doesn't cite the code of conduct for expert witnesses, and I just wondered what the reason for that is.
Certainly.
Is it simply because it's corporate evidence and not an expert brief, or can you elaborate on that?
Yes, and you're right, and I apologise for that omission. It should have said statement of evidence on the cover page. It is certainly intended as evidence. It's corporate evidence only, therefore he does not need to adhere to the code of conduct, and we were quite concerned to ensure you had an operational perspective here on something of absolutely vital importance to the all of the fuel codes, and Mr. Tinnelly, I'm sure, would welcome questions on any operational issues.
Yes. I don't think that's in dispute, and as the chair said, it was just a matter of the process and procedure, but I'll leave it at that. Thank you.
Certainly. Thank you. Thank you.
Good morning, Mr. Enright. It's Commissioner Jones here. Thank you for your submissions and your presentation today. I imagine that you will anticipate some of my questions about the NPSI based on previous comments you made. I'd like to come back to those in a second, but while you are fresh off your response to Commissioner McMahon's questions, I just wanted to talk about the scope issue and your acceptance of Mr. Quinn's opinion. Mr. Quinn also referred us to limitations under plan stop. And I just wanted to ask you firstly whether you are aligned with Mr. Quinn in that respect, that the panel is also limited by plan stop?
Yes. I haven't because I only got Mr. Quinn's opinion last night. I haven't looked into any constraint on your jurisdiction under the plan stop, but I agree in principle with his point. My understanding is we're not under a plan stop. Therefore, for the purposes of your hearings, so that doesn't apply specifically to NPSI, but I'm happy to look at that further if it becomes important because it's something I wasn't able to look at, unfortunately, in the time.
No, that's a helpful preliminary view. I think the only matter of detail, I think, before the panel at the moment that's relevant to your client's submissions is the definition of sensitive environments. And Mr. Wesney has made clear in his, I think it was his errata, that the definition that was mooted by your clients refers to various overlays. And those overlays, I think, are subject to plan stop.
In that case, perhaps I might, with your leave, with the chair's leave, just address this in a short legal submission. I could get that within 7 days or something, just to give you a clear answer if that's indulgence is allowed for.
No, I think that's very helpful to us. So,
thank you.
Yes, so we can get it sometime next week. That would be appreciated.
Thank you very much.
Thank you. I think it's also just one for the planners to be mindful of for conferencing.
Absolutely, yes, no, 100%. We wouldn't want them to conference on redundant issues.
Thank you. One of the last points that you raised in your summary about the wharf lines and about the lack of a QRA currently available to us. I just wondered whether you think that is an information gap in the context of Section 32 and whether the panel would benefit from a risk analysis associated with that.
So I can give you a legal answer, but probably Ms. Pollock might give you the best technical answer. So perhaps I'm happy for her to wait her turn or answer it now. But from the legal perspective, I'd submit it. It's not an information gap. I mean, of course, it might be nice, but you've still got sufficient evidence available to you to include a corridor as recommended by Ms. McPherson. And so it's not, you don't have to, it's not a showstopper that there's no QRA, as long as you have reasonable evidence that addresses 32AA. And my legal submission there would be, yes, you do have sufficient evidence to impose a relevant corridor. But however, again, I think all three planners here have agreed there could be a bit caucusing on what that looks like and whether what the fuel companies have recommended is, does meet the 32AA test, or whether activity status might be, in a range at a lesser level than non-compliant, for example, those kinds of things. But my submission certainly is you do have the evidence. Ms. Pollock could give you a useful technical answer, and maybe she should just reserve that till her turn.
Yes, I think that's right. I think your suggestion that Ms. Pollich and Ms. van der Monkoff also confer on these technical matters that are outstanding. I think that's potentially the channel to resolve that. I was more looking for what I think you to be accepting is that the panel would benefit from a 32AA, wherever the planners might end up, that sort of comprehensively puts that technical evidence in context and if you like, pulls together all the relevant matters that the panel will have to report on in its decision.
Absolutely. Now, whether that extends to a QRA is not a question I can answer, because my understanding is it's quite a involved and very expensive exercise, and whether it's needed is something I defer to Mr. Tinnerley and Ms. Pollich on, so they can comment further on that.
Thank you.
But I agree otherwise with your summary. Thank you.
That's helpful. Okay, I do want to talk about the MPSI, and I just want to be absolutely clear on your submissions. And your point about the directive language in the MPS is very clear to the panel. We're familiar with the case that you've referred us to and to the clear direction of the court in that particular case. So that's helpful. Thank you. I think the question I had more related to the interrelationship between these three policies, and you've helpfully clarified to the panel that we do need to read the instrument as a whole. I just wanted to understand where you say that enable and not compromise, being the active words used in 8, 9, and 10, where they have a similar directive focus. And then I think at paragraph 60 of your submissions, you say the infrastructure must be enabled, including by management of incompatible activities and by ensuring the infrastructure is not compromised. I'm just wondering if you're inviting us to read that the not compromising direction under policy 10 is a means of implementing the enabling direction under 8 and 9, or are they all independent policies that we just consider at face value?
The great question. The answer is, again, reading them together. Well, starting point is, as you've indicated in your question, we are dealing here with directive language. It's not a may, it's not a discretionary type language, both as to the word enable and not compromise. So that's a starting point for me. Whether the language in policy 10 bracket 1, which refers to not compromised, is a separate directive verb to enable. So it's not quite the same.
Yes.
It's not the implementation of policy 10. And for example, policy 10 isn't subservient, so to speak, to 8 and 9.
Yes.
Would be my probably the answer to that question. And, on reflection this morning, again, when I was just rereading the MPSI, in some ways, policy 10 merits greater weight for your panel's purposes, because again, it's specifically directed to a PDP type process, whereas the others, 8 and 9, while still relevant, potentially also relevant from a resource consent, or designation perspective. And the policy 10 bracket 2, you'll note the mandatory must in there. So this is where we thought, well, actually, we really need to give you some operational evidence, because we are the operate infrastructure provider, obviously. And my thoughts on, for example, 10 bracket 2 bracket A bracket 2.
Yes.
It's got that dual focus on both sensitive and incompatible activities. So it's not just a monolithic focus on sensitive activities and risk to sensitive, which seems to be a point Ms. Blackwell was trying to pick up in her rebuttal, but actually in the same sentence it refers to incompatible, so sensitive and incompatible. So you might be incompatible without being a sensitive activity, which is our very point in terms of the types of activities the Marina are trying to introduce through their vision.
Yes.
And then, of course, it also refers to direct effects reverse sensitivity effects and risks, health and safety. So it's quite a multifaceted approach. But just going back to your question again, again on a reread this morning, for example, policy 5's fairly relevant. Of course, the single objective is relevant to you in reading all of the policies in the instrument.
Yes.
Some are not relevant because, for example, we don't have spatial planning processes in play just yet. That's policy 3. But certainly some of the definitions assist. So, yeah, in summary, we do read it as a whole. 8, 9, 10 of particular relevance. There are some other policies of lesser relevance, and the enable and not compromise are directive verbs, but should be read independently in my submission. Hopefully that answers the question.
Thank you. Yes, that's very helpful. Looking at the first subclause under policy 10.2a, there's a direction for the panel to understand the existing and planned infrastructure activities in the medium and long term. I think that's potentially one further matter that the panel would benefit in this particular case for this particular piece of infrastructure or pieces of infrastructure, so that we have that factual background that we can turn our mind to. So just signaling that would be something we'd like to hear from your clients on.
Thank you, and we'd strongly encourage that, and again, Mr. Tinley can speak to that. We have tried to give you the context of the current fuel crisis in New Zealand, and it is relevant, in terms of the definition of environment in the RMA to consider how resilient are we, how resilient are these seaview terminals, and what do we need to do to ensure their existing and planned future pathway forward. So I won't say any more on that.
Thank you. Just one more question on that policy suite. Policy 9.2, it brings into play Section 6 of the Act. And
Yes.
I don't think in any of the evidence before the panel at the moment has anyone turned their mind specifically to any Section 6 matters that might give rise to any nuance and approach here. So again, I'm just wondering whether matters like 6D or 6H might be relevant considerations for the panel.
A really good question, and I'm not aware of any case law emerging yet on what that. I find that a most fascinating provision.
Yeah.
And one could think of the NZCPS, for example, as relevant, but here we're dealing with land-based,
Yes.
landside. So although it's public coastal environment, it's not, CMA obviously. So it's sort of, it's not a matter raised in the evidence as relevant to you, and to the extent that there was any relevance, you'd still have to contemplate, are there any competing national direction instruments here that relevantly raise Section 6 issues? Unlikely, unless it was NZCPS, and again, we're on the land side of CMA. So it's fairly, it's a hierarchical approach, but my submission is there aren't any other national direction instruments that would trigger competing Section 6 values.
Okay, thank you. I think it's probably a question that we'll ask the planners to turn their minds
Certainly.
to. Yeah, thank you. That's
Thank you.
Very helpful, Mr. Enright.
Morning, Mr. Enright. Commissioner Muspratt here. Thank you for your legal submissions. As I began reading through them, I did have a lot of questions, but as I worked through, you actually answered them all. What I found really useful was basically stepping through how the courts have applied the remaining provisions of the RMA as a package of relevant legislation, relevant to district plans. My question is, can we have copies of that case law, please? Commissioner Jones says he's very, very familiar with it. But yeah, for my benefit, that would be really useful. Thank you.
Yes, and with the chair's leave, I'd be happy to attach the decisions that I've referred to in my legal submission, and if you would like them, I could give you Mr. Quinn's cases he referred to in his opinion of 8 May, but within that same 7 days. But I'll wait. If that would be of assistance, I'd be happy to do that.
Yes, that will be of assistance. Thank you.
Okay.
I have no additional questions. So we hear from your
Thank
team
you.
now.
Yes, so the proposal was Mr. Tinley would go next, then Ms. Pollichin, and the sweeper role, as always, for the planner, Ms. McPherson. So thank you. I'll put myself on mute.
Mr. Tinley.
Yeah, kia ora koutou. I'm Matt Tinley. I'm Engineering Manager for Z Energy and Lead Technical Authority. My evidence that was provided addresses concerns regarding the role of the terminals, whether the risks are being appropriately managed and whether planning provisions should be more conservative. As the evidence describes, the role of the Seaview box storage terminals is that of a critical lifeline infrastructure for Wellington and the Lower North Island, and they enable the import, box storage and distribution of liquid fuels across that region, but also the ongoing supply to retail networks, industry, and of course emergency services. They're recognised within the civil defence frameworks as essential for maintaining critical services during emergencies, and there are a couple of examples provided in my evidence of that. The nature of the risks of these facilities is that they are very large. They store very large volumes of flammable hydrocarbons, and while classified as lower tier major hazard facilities, that classification reflects regulatory thresholds and not necessarily low risk. The risk profile is low likelihood, but high consequence, particularly in the event of a loss of containment and subsequent ignition. Risk is managed through a mature and robust framework, including the major hazard facility regulations that require risks to be reduced to a level we deem as so far as is reasonably practicable. Formal safety assessments and emergency planning and compliance with recognised standards such as those from the American Petroleum Institute, API, or the Australian or New Zealand Standard 2885 that is directly impacted on the wharf line. This is supported by multiple independent layers of protection that include, but are not limited to, overfill prevention and high integrity shutdown systems, engineered containment systems such as bunding, and then inspection, maintenance and verification routines associated with critical controls that we have in place. I should add that these controls reflect the established international best practice, including lessons learnt from the Buncefield incident that occurred in England in the early 2000s. The key point is that risk with these terminals is certainly not static and that it is dynamic. QRA risk contours change over time as a function of the product mix, which may be stored on those sites, the storage configuration, and also the throughput of fuels at those sites. The operational reality is that we need the ability to upgrade infrastructure, reconfigure storage, and optimize operations to maintain both the safety and supply resilience. New terminals are not realistically feasible due to significant cost and consenting constraints, and therefore, if there were to be any adaptation, it would be within the existing footprint. Pipelines and encroachment are another topic I touch on. Wharf line, or the Hutt City Wharf Line, as it is referred to, is a critical shared asset and is managed under the standard 2885. The primary risk is third-party interference, particularly from adjacent developments. Most importantly, changes in surrounding land use can increase consequence and trigger additional controls, and this creates a direct link between the planning decisions and also the pipeline risk that we manage as the operators. There have been suggestions that to reduce risk, we should do so through operational changes, such as lowering pressure or restricting our scheduling. We believe that these are not generally practicable. They would disrupt supply chain, and they would introduce significant costs, including vessel demurrage. Risk cannot simply be engineered out operationally without material consequences. The core issue for this panel, I believe, is that there is a direct relationship between adjacent land use and risk exposure. encroachment or intensification of sensitive activities increases societal risk, reduces effectiveness of existing controls, and may trigger more onerous regulatory requirements. In conclusion, I would say that these facilities already operate under a robust best practice risk management framework, and that framework depends on appropriate land use and planning to remain effective. Therefore, a conservative and precautionary planning approach is necessary to recognise high consequence risk, accommodate the dynamic nature of this risk, and avoid incompatible neighbouring uses, but also preserve the ability to adapt and upgrade infrastructure as and when necessary. And as Mr. Enright points to, this is a contemporary issue, noting the current geopolitical crises around the world. Without this, both risk outcomes and fuel supply resilience may be compromised, and I therefore support the planning provisions advanced in the submission shared by colleagues Ms. McPherson and Ms. Polich. Thank you.
Thank you for that. Very useful explanation to us. Questions? Who wants to go first? Jason?
Good morning. Welcome. Thank you very much for your statement. I just want to ask a couple of questions of clarification, really. In some of the New South Wales guidance that we've been referred to, there's different controls and guidance provided on the different hazardous substances that are referred to. So I'm looking at paragraph 2.1 of your statement, and I just want to clarify from your perspective, is that an exhaustive list of the materials that are dealt with at Seaview at the bottom of paragraph 2.1?
I would suggest there are other substances contained in I suppose lower quantities.
Yes.
They may be products related to additives which the various companies will use in their fuels, but for the purposes of I suppose the higher volumes,
yes,
it is those products that are referred to, Commissioner. Yes.
So in the context of the planning provisions that we're considering, those are the relevant hazardous substances?
Yes, that's correct, Commissioner.
Thank you. I just wanted to ask two questions about paragraph 3.5. And in particular, Buncefield, and it's obviously, this is a bit of a watershed episode based on the evidence that's before us. There's been quite a lot of reference to it. Would it help the panel to perhaps understand some context there about what the applicable regulations were underpinning the operations at Buncefield versus where, as an industry, we've gotten to now, particularly in New Zealand, just so we can understand, with that as an example that's cited as an instance where things went wrong, what steps have been materially adopted by the industry to prevent that and are embedded in practice at Seaview?
Yes, certainly, Commissioner. So for those that weren't aware, I think it was around about 2006, a rather large fuel storage terminal, larger than in size than anything we have at Seaview, experienced what we call an uncontrolled overfill.
Yeah.
Subsequently, motor spirit, I believe it was 91 motor spirit, leaked into the bunded area, and the conditions were such, as we talk about in a process safety context, it's never one thing, it's many, but the conditions were such that it was optimal for what we call a VCE, or vapor cloud explosion. That resulted in a significant fire that I believe took somewhere in the realm of about a week to bring under control, consumed massive resources across the United Kingdom. And as you described, Commissioner, was certainly a watershed moment for fuel companies the world over. What subsequently fell out of that, as has been experienced, for example, after Piper Alpha and other, again, watershed moments, is the government of the United Kingdom convened a panel. That panel released the findings. It was initially called the Buncefield Safety Task Group, BSTG. It has another name now. There are essentially around 13 findings that it released as part of that, and it outlined, what was missing or what was substandard on the basis of the events leading up to that incident. Of those 13, they range from safety management system, I suppose, adherence or robustness, right through to physical engineering controls fitted on site. To give you an example, and again, I won't speak on behalf of the other companies, but certainly for Z Energy, examples of those systems include, as I say, a robust safety management system, which includes, all matters relating to how we operate, how we maintain, and also how we consider upgrades for our infrastructure. Engineering controls that we have automatic overflow prevention systems, so they're an independent, what we call a SIL-rated system, so they have a safety integrity level that's an accredited standard that we, and there's definite architecture that we must have to reach that accreditation, if you will. For that, and that's one of the systems that wasn't fitted. We also have what we call vapor detection. So in the event that there may be a leak from a pipeline, a tank or a pump or otherwise, we have sensors that will initiate an automated shutdown of the site outright. And then there's, of course, there are systems that will then notify the likes of our operating staff, but equally local emergency services, depending on the nature of the incident that may be detected.
Thank you. Just on the vapor detection, is that sensors placed at intervals along the way?
Yes, it is, Commissioner. There are, I think there's about 3 different types of sensors around a site, for example. And again, this is in the case of Z Energy, and that's on the basis of under various process safety risk assessment instruments, we've determined that that would be the most appropriate sensor. So, for example, it might be what we call a point detection sensor, not dissimilar to, say, the fire and gas, other fire alarm sensors that we have in this room here. There may be what we call line of sight sensors, and there'll also be float sensors as well.
Thank you. I'm guessing, and this is something I can clarify with the parties who've joined in on this particular issue, but some of the evidence from others has sort of questioned the full extent of the safety measures that you've adopted. But I gather that that's precisely what this part of your evidence is intending to address. You were setting out a full inventory of all the safety measures that are now applied at Seaview, so that those who've questioned what measures are in place can have an understanding of all those measures?
Yes, it does, Commissioner. The other thing I think I would add to that is that this is part of the suite, as it were, of requirements placed on us by the regulator being WorkSafe, and it directly affects our licence to operate. So, without demonstrable risk management, be that through, procedural engineering or elimination controls, as it were, we simply wouldn't be allowed to operate by the regulator. And I should add, they inspect the sites on a regular basis.
Thank you. That's all I had.
Thank you, Mr. Tinley. I don't have a specific question for you. I've made some notes based on your answers to Mr. Jones, but I noticed that, thank you for the Buncefield background. I noticed we have a real life example in the United States at the moment with a leak from a additive storage facility in association with plastics manufacturer, I think. I'm not sure how that's resolved in the last 48 hours, but no doubt you've been watching that intently yourself.
I have, Commissioner. I get the updates from the United States Chemical Safety Bureau come through my emails quite regularly.
Yes. And that was in California, was it? Or
there's one in California and there's one in Washington State as well, right, Commissioner, that we're certainly watching to understand what the mechanisms of failure are, and if there are lessons learned.
Yes, one of the interventions there that the news broadcast that I saw was evacuations, and is that a sort of the final backstop type situation in management?
When we talk about process, well, I suppose when we talk about Process Safety Commission, we talk about bow ties and bow tie diagrams, which are a key visual statement in terms of how we manage risk at our sites. If we're at evacuation, that's on what we call the right-hand side of the bow tie. And the whole premise of process safety is that with a bow tie is that you never want to get to the right-hand side. That's in the space of of mitigating risk as opposed to mitigating, I suppose they're, what would be the word I'd describe? They're post-event actions, as it were, as opposed to preventative actions.
Although I guess they are, depending on the stage of the event, they can be preventative too in terms of exposure.
Potentially, Commissioner, yes.
Yeah. Okay. Look, there's no particular question there for me. I just wanted to acknowledge that that's an example that I've been following myself.
Oh, I don't have any specific questions, but what I am somewhat concerned about is the timing. We have another submitter scheduled at 11, which is obviously very case in point, being the Seaview Marina. Perhaps, Ms. Blackwell, are you available to delay for a wee while? And I'm also conscious, can somebody potentially get in touch with Mr. Beban and find out, I'm thinking we'll go with the two submitters, accept Mr. Beban this morning, and then we'll deal with the rest of the material this afternoon. But if Mr. Beban can perhaps come at 1 o'clock, it would be good. If that's inconvenient to him, can he suggest an alternative today? But we're with 50 minutes into the 1 hour slot for this submitter, and we've still got 2 witnesses, and very important witnesses they are as well. We also need to take a break at some stage too, but what I suggest is we'll continue with the next witness and then take a break. It's agreeable to everybody? Thank you. Mr. Enright.
Thank you, Mr. Chair, and Ms. Pollich will now address you.
Hello, can you hear me?
Yes, that's loud and clear. Thank you.
Great. Would you like me to just start with a summary?
Yes, that would be preferable. It's just a summary. We obviously have read your evidence and your rebuttal, but if you can summarise the key points, that will be useful to us.
Right. So, as you're aware, I'm Jenny Pollock. I'm a principal engineer at Sherpa Consulting. My probably last 20 years has been in process safety, supporting largely high hazard industries with managing risks. I have been directly involved over the last 10 years in quite a few district plan updates in New Zealand that have involved implementing risk overlays in a planning instrument, which I have sort of summarised in my evidence. So I guess the 3 main areas of my evidence are around using risk overlays to manage risk around facilities like fuel terminals and pipelines, specific choice of risk criteria that you can use to manage those overlays, and applicability of that to both pipelines and fuel storage terminals. So I guess just to reiterate the point of the overlay, and it's, I guess, 2 separate points. One is to make sure that there's adequate separation distance to between a hazardous facility and activities that might be sensitive to potential incidents that occur on those kind of facilities. And the other main reason is to try and avoid encroachment of activities or populations that might elevate the risk from the hazardous facility. So I guess there's two separate but related points. One is about sensitive populations, like in land use planning, that typically means populations that are difficult to manage in an evacuation sense. And I guess that means a industrial population in a building that has an emergency plan, it's much easier to manage that than a residential population in a high rise or an aged care facility or something like that. So that's what sensitivity means in land use planning. It often does not match definitions of sensitive in other planning instruments, which cover all sorts of other things. And I guess the other point is that separately to that, the number of people that are potentially affected by a hazardous facility is a relevant consideration for risk. So that's separate to sensitivity. That's just about numbers of people, really. So that is where sort of intensification or land uses that may not be sensitive in the difficult to evacuate sense, but cause a lot more people to come into the potential effect area of a sensitive activity is relevant. So I guess I just wanted to make the point that, which I think I've made in my evidence, that sensitivity and numbers are not the same thing, but in the planning instruments, a lot of the time, a sensitive contour has been used as a sort of de facto way of managing numbers. And that is because it's a lower risk criteria, and also the definition in the planning instrument of sensitive activities can then include things that are more population intensive. So I just wanted to make the point that they are separate issues, but sometimes they become conflated in a planning instrument. And that's really because it's quite difficult to explicitly manage numbers in a planning instrument. So by putting a density cap or something like that, it's quite a difficult thing to do from a planning point of view, in my experience. So I just wanted to make those points. Then I just wanted to reiterate that there's two types of risks that are typically considered in planning. One's individual risk, and essentially that is a function of the source of risk, and it can't be changed unless you change something about the source of risk. So Mr. Tinley's talked about the nature of the operations and the engineering controls that are in place at the terminals. So those kind of things can be factored into individual risk assessment. So that basically is what produces the contours in a QRA. So they are not affected by numbers of people. They are simply a function of the source of risk, how often they do things, the quantity, the throughput, and the nature of the engineering safeguards. Then there's societal risk, and that really is a combination of that individual risk. So it's the risk at a location combined with the probability of presence of people and how many people there are. So they're the two usual risk types that are used in land use safety planning. So yeah, I just wanted to explain, I think I've said it in my evidence, but I mean, my position is that the sensitive individual fatality risk contour, if you're going to choose one contour, is the best compromise for managing both sensitivity and population intensification. So I just wanted to make that point. And what else? So I guess the other point I wanted to make is, context in risk assessment is really important. And in the different district plans I've been involved in probably over the last 10 years, I did put a table in my evidence, but there has been a bit of reference in, I think, the 42A reports and things like that around South Taranaki and New Plymouth district plans. It's a really different context. It's rural areas with a lot of risk sources in the form of oil and gas wells and production facilities and very low populations. So really the only material consideration is individual risk, and population intensification isn't an issue. In other areas that are more similar to Seaview, intensification and introduction of more sensitive populations is a potential issue, particularly when you're thinking about mixed land uses. Hence, we've tended to use the sensitive land use contour or some combination of other things in the case of stuff around the Wasl terminal. So I just want to make it clear that context is quite important to understand, and it's not really a one-size-fits-all approach. And then I guess the other point about the pipeline, I mean, yeah, it's not compulsory to have a pipeline QRA. Typically, pipeline risks are managed via AS 2885, which really is extensive guidance around how you manage the operating and maintenance and design of a pipeline. But the land use planning, I suppose, trend, particularly in Australia, has been to use QRA to manage specifically intensification around existing pipelines and to avoid encroachment of sensitive activities, and also obviously to manage construction activities that could damage the pipeline. So in my view, you know, there's no real difference in approach just because it's a pipeline. And yes, as I have pointed out, some of the risk information is quite old. And certainly you could have a new QRA that could more explicitly address some of the safeguards and things that are in place, but you're still going to end up with some kind of corridor around the pipeline. It might be a slightly different distance to 40 metres, but you will still end up with some kind of corridor around the pipeline where you'd want to manage population and other encroachment activities. So, I mean, I guess they're the sort of main points that I wanted to make. And I did just want to have just a quick word about temporary high populations like markets and things like that, which I think I noted in my rebuttal evidence. And again, just to support Mr. Tinnerly's statements, we do a lot of work in terms of assisting operators to assess what kind of control measures are reasonably practical. If you're a major hazards facility, you have to make a fairly strong demonstration to a regulator in both New Zealand, Australia, and other jurisdictions that you've adopted all reasonably practical control measures to reduce your risk so far as reasonably practicable. Things like operational constraints for terminals are never accepted as reasonably practical because you just can't control operations in that way, except for perhaps one-off and long-planned events. So some examples of that in New Zealand are things like at the Littleton Port area. SailGP was held there a couple of years ago, and that certainly involved shutting down all transfers of hazardous materials and extensive emergency planning. But that was a long, a lot of people, and it was a long planning event. So you can certainly manage it in that context. It's much more difficult to say, oh, every Sunday or every Saturday, I'm not taking a ship delivery over all the terminals in a particular area. So those kind of things, whilst, yep, it is true that a ship import activity is the highest risk for a fuel terminal, it's very difficult to manage operations to eliminate coincidence with a temporary population. So I guess they're probably the main things that I wanted to talk about.
Thank you for that. That's very helpful explanation. Looking to my colleagues, questions? Well, you go, Jason.
Good morning, Ms. Pollock. Thank you for getting up slightly earlier than all the rest of us. It's Commissioner Jones here. This is, well, I'm going to invite you to respond to this, but it's equally an invitation to Ms. McPherson and also to the marina experts that are going to be appearing shortly. So it's an open invitation to receive a response from all four of you on this series of questions. But I'll put it to you first. My reading of Mr. Wesney's rebuttal and Mr. van der Monkoff's evidence, they've expressed the view that adopting the 0.5 contour would result in a more conservative approach for some activities than the HIPAP framework. Do I have that right?
Sorry, that the sensitive activity contour is more conservative, larger. Yes, that's correct.
Okay, thank you. And obviously, Mr. Tinley's attached to his statement the Auckland Plan model. And one of the questions I asked Mr. Westney yesterday was about the concept of similarly looking at more than one contour to manage activities in a graduated way. Mr. Wesney said that that's perhaps overly complicated for the Hutt City context. And you've urged us to think carefully about the Hutt City context. So I'm just wondering what your thoughts are on the idea of an inner and an outer contour, if you like, with different potential controls on activities within each.
Yeah, so my opinion on that, I mean, we haven't raised it, but it is actually in place in the Auckland unitary plan. So there's two contours there. One is like a design constraint overlay, and then there's a larger contour, which is the emergency planning overlay that has the effect of restricting sensitive activities and also requiring developments in that area to have an emergency plan that acknowledges the potential risks of the Wasl terminal. So, I mean, I see no particular issue with adopting that approach. I guess it's more flexible in some ways. So yeah, I certainly would be not adverse to that approach. I mean, yes, it is more complex in the sense that you have to agree to things, but it might address some of the concerns that are different between intensification and sensitivity.
Yes.
Yeah.
And might that also feed into different controls that might be needed for the wharf line, distinct from the terminals as well?
Yes, and it would allow you more flexibility with, I guess, those classifications that apply in New Zealand to planning controls. So yeah, in my view, that is something that could work. I'm certainly not against that.
Thank you. I think that's probably all I have from you now, but that I have for you now. But I think if the offer stands for yourself and Mr. van der Monkoff to assist the panel further, we'd be grateful for that.
Yes, I'm certainly happy to do any kind of expert conferencing or caucusing. That's been the case for many of these plans, so usually it's worked quite well.
Thank you, and thanks for your evidence.
Thank you, Ms. Pollich. Just to reiterate Mr. Jones' comment about you getting up early after the big event last night with the Origin. Sure,
yes,
celebrating that. Look, I don't have any questions, but any questions that we do have will be reflected in the minute that will be circulated in terms of directing conferencing for all of the parties. That's all for me. Thank you.
We have no further questions. Obviously, this is an evolving situation, if you like, in terms of our current thinking and what has been put to us and what is likely to be put to us later this morning as well. But we appreciate your evidence, nice and clear and very helpful in what is a relatively complex technical subject. So that is very useful to us.
Thank you.
Thank you. I think we'll take a break now and come back at 11:20 and we'll deal with Ms. McPherson's evidence, and then we'll hear from Seaview Marina. Thank you. Okay, we'll reconvene the hearing. Ms McPherson, you've got 2 briefs of evidence. Suggest you deal with the hazardous substances / Seaview Marina zone evidence first, and then we'll deal with the other matters after that. That's all right?
Sorry. Are you wanting me to run through a brief summary or just respond to some questions and come back to some of the points that have been raised in the last couple of days?
I always find a brief summary is useful, as long as it's sort of brief, because we're getting conscious of the time as well.
Yep, absolutely. So just to try and run through things briefly, I think a key point is that the primary driver for introducing the risk management overlays into the plan at this point in time, obviously is a plan-making process, but as part of that, the zoning of the Seaview Marina land is proposed to change from a recreation zone to this mixed use provision for quite a broad range of different activity types. And so that in itself does open up this quite significant potential for inappropriate risk and review sensitivity to occur in relation to the proximity of the fuel terminals. Fuel companies have worked closely with the council through the process of developing the draft district plan, the proposed district plan, to try and look at a bespoke approach to managing risk in this location. And in this context, the characteristics of the Seaview Marina land do mean that there are some quite unique constraints around the accessibility. There's essentially access in and out via only one road, which means to exit the land, you've got to cross over the pipeline and you'd be travelling towards the terminals, being the source of the risk if there was to be an emergency incident. And so on that basis, we have looked at a relatively conservative approach, a precautionary approach. The use of the sensitive activity contour, 0.5 in a million, rather than the 1 in a million contour, is something that we consider is quite important in this location, partly because of those underlying constraints around the accessibility in and out of this site. Also, I think the point that Ms. Pollich raised, and I'm not sure if we've still got them actually, they're not on the screen.
I'm here, Georgina. I'm not sure why my camera's on, but anyway, I'm listening. Thank you.
Ms. Pollich raised a point around the distinction between the modelled individual fatality contours and the broader societal risk issues and the population numbers that come along with that. And the difficulty in drafting provisions that look at managing societal risk in terms of population numbers. And I do support her comments on that, and it's something we looked at quite closely in terms of our understanding of the marina's aspirations to have commercial or office type activities that would potentially introduce large population numbers as distinct to the more sensitive activity types, and how that could potentially be managed here. We looked at plans across the country, and we haven't come up with any other examples where a population-based threshold was being used, or any scenarios where that might be workable. Particularly when you're looking at it across a broad area, you might have a number of different landowners or developments, and how could you keep track of that cumulatively with development occurring over time, and particularly if that was to be set at a difference between a permitted activity versus a consented pathway. I think it would be quite a difficult thing to achieve. And this is where we've come to a point at this stage in the proposed provisions of having office activities included in that definition of sensitive activities, as Ms. Pollich was saying, to sort of act as a proxy in terms of capturing the population numbers as well as those more sensitive activity types. And that is something we consider is important to capture as well, again, based on our understanding of what the Seaview Marina is considering in this area, and some of those potential activity types were highlighted in the statement from the CE as well, which did suggest some sensitive activities in there. The unitary plan provisions that were attached to Mr. Tinley's evidence, I think are one example of where we have looked at a bespoke approach to managing the risk in relation to a specific facility. That and another very recent example is in the Napier proposed district plan, which is now at decisions stage and going through appeals. These provisions haven't been appealed, is where there are residential activities immediately adjacent to the terminals. So it was a very finely balanced approach there. We ended up with a set of risk management provisions that are based on a mapped overlay, but that overlay doesn't follow the contour of the individual fatality as mapped by the QRA. In that location, we've taken a whole of site approach. So we've taken on the rationale that the risk doesn't start and stop on one part of the site versus the next part of the site, and you'd be wanting to manage risk overall, so that you can't say one part of the building is safer to be in than the other part. And if you're looking at things like emergency response and exit in an emergency scenario, everyone would really need to be taking the same action. So there's potential for an approach like that at Seaview, where you've got a discrete area of land, all of which would have to funnel out through a single or two access points with very similar constraints around crossing the pipeline and heading towards the terminals. So, and this sort of is partly where what I think sits in behind the suggestions from the various parties to look at how we could develop something that's going to be workable, that achieves as much certainty as we can at this point in time. And I think that it needs to be considered in the context that these terminals aren't necessarily entirely static activities. They do change over time. There can be a need for a switch out of products. Things like the minimum stock holding requirements that the operators are required to adhere to are potentially up on the table in the current climate, where there's been signals from the government that those may need to be increased. And certainly if there was to be a direction like that, the logical place to look at expansion would be these sites, and not trying to come up with a new location somewhere else in the Wellington region that doesn't have that connectivity to the fuels pipeline. And on the flip side, we know that the Seaview Marina is looking at diversifying and exploring options for development of that land, but at this point we don't know exactly what that might involve. And so I think there's going to need to be an assessment process at a time of specific development proposals coming through, so that we can really understand what those what the acceptability of the land uses are, those risk management measures, and how they're implemented in relation to a specific proposal. Just touching on the corridor management approach for a fuels pipeline, and I just flagged that at para 7.6 of my evidence. I did note that I wasn't aware of, a pipeline approach being incorporated in New Zealand planning documents yet. I actually intended that to refer more specifically to the most recent guidance from New South Wales, which has just come out in 2024. The unitary plan does have a pipeline corridor management approach in relation to the former refining to Auckland pipeline, the Marsden Point through to Auckland. Those provisions predate this particular piece of guidance from New South Wales. there's certainly other examples of pipeline corridor management approaches, and even in the proposed plan here, there's a corridor management approach in relation to the gas transmission pipeline. And so I think that's a very clear example of precedent for this plan to adopt a similar approach in terms of the management of risk around lineal infrastructure. I did want to come back to the discussion on sensitive activities and the fuel company's submission on that and some of the questions from the panel yesterday. And perhaps a slightly different perspective on it would be that my experience has been being involved in various district plans, in particular since the 2017 Resource Management Legislation Amendment Act removed the function of managing hazardous substances from district and regional councils. There's been a lot of dialogue and a lot of guidance produced around what role councils may continue to have in the management of hazardous substances. There's been quite a lot of focus on where a gap might be that beyond the primary has no and work safe legislation in terms of where the RMA fits in, and around the idea that this might be in more sensitive receiving environments. And so what I've seen come through in district plans is referencing to sensitive environments as being sort of an elevated or a rationale for having a hazardous substances control. But I would say that that is typically quite clearly defined in terms of the type of definition that had been sought in the fuel company's submission, which was the reference to the specific overlays. In other cases, I'm aware of in the proposed Napier district plan, which is quite a recent example, they've specifically identified the unconfined aquifers of the Heretaunga Plains as the sensitive receiving environment, which forms the trigger for additional hazardous substances controls. So certainly different councils have taken different approaches to that. But what I've taken from that is that there has been a real focus on being able to define what that sensitive environment is for certainty in a consenting context. And I think in the context of this plan, where you've got a policy directive to avoid locating in a sensitive environment, there does need to be certainty around where that is and where that isn't. I acknowledge there's potentially a scope issue with those overlays having fallen out of the current process through plan stop. I think the driver of the fuel company's submission, and probably of others, is that there needs to be a clearer definition around what sensitive environments is. So it may be that there are alternative ways of defining that. It may be possible to look back at the referencing in the operative plan around how certain natural environments may have an additional layer of protection through existing overlays. I think probably the clear distinction is that there's a focus on both managing the human health and risk effects, and then the effects on more sensitive natural environments. But again, needing to have that certainty around where that might start and stop in a consenting context. I also had some comments on reverse sensitivity, and I know that acknowledge that sort of crosses over into the other piece of evidence, but there are crossovers along the way, and it, I think, also speaks to the discussion on the NPS infrastructure and the directive approach that's signalled in that document, and ties in with the submission points on policy wording and changing that focus to an avoidance of reverse sensitivity rather than sort of softer management approaches around reverse sensitivity. I support the comments from Ms. Whitney for Transpower earlier. I probably don't have a lot more to say on that. I do think that the definition as drafted both in the notified version and in the officer's report is quite complex and problematic, particularly the incorporation of the qualifier that to be a reverse sensitivity effect, it has to be a significant unreasonable effect. To me, if you've got that sort of direction, that's something that could appropriately sit in a policy, but not in terms of the definition of the term itself. And I share Ms. Whitney's concerns that could potentially mean a reverse sensitivity effect is not actually classed as a reverse sensitivity effect under that current drafting. Acknowledge also that if that definition was to change, there could be flow-on effects in terms of how it's expressed in the remainder of the plan. I think from the fuel company's perspective, we've tried to cover that in terms of the submission points on the policy framework, and taking what to me is a more commonly understood and accepted definition of reverse sensitivity, translating that into the submission points, drawing that into the regionally significant status of the fuel terminals, and that need to avoid reverse sensitivity effects, I think is consistent with that direction in NPS infrastructure. And in terms of the industrial zone provisions in particular, I'm sorry, I know this is crossing a bit more into that part of the evidence. I think where we've tried to go with that is to focus primarily on what would be a land use compatibility issue between a more sensitive activity and a more traditional industrial activity that you'd expect to be in these types of zones, rather than my understanding of the current drafting, which appears to be trying to also manage reverse sensitivity effects between a range of different industrial or commercial activities within a zone at a sort of a finer, maybe a softer level, but that under that traditional interpretation, it's really much more of a contrast between your effects emitting activity and industrial activity versus a sensitive receiver. So I think my thinking on that would be that there is scope to address those flow-on effects from changing the definition of reverse sensitivity through the zoning provisions as well. And sorry, just to pop back to the risk management provisions, and it's something that Mr. Tinley and I were discussing over the break, is just there was a brief discussion on the emergency response and in the context of some of the events happening overseas at the moment, and the comment around evacuation and the zone of evacuation where people might be subject to that sort of response. And just wanted to clarify that the contours that are mapped through the QRA process are based on both a consequence and a frequency type evaluation, and Ms. Polish could certainly explain this more clearly than I can, but they result from also taking into account the various mitigation measures at the terminal, and so that reduces the frequency of the effect and therefore the extent of the contour, and looks at the likelihood and the acceptability of the different land use types within that zone. If you were to look purely at consequence contour, that actually would extend a lot further than the modelled contours. So if you were to be in an emergency scenario, potentially would be looking at evacuation of people beyond the modelled contour through a QRA.
Wasn't quite the brief summary I was thinking, but no, that was useful. I'll ask my colleagues for questions. You want to go first? for you, Jason.
Me again. Thank you for that summary. It's addressed a lot of the questions that I had written down in your evidence, so that's been really helpful actually for me. I took quite a few notes. I just wanted to ask you about the point you traversed with specific reference to the commercial and office activities in the marina zone, and how your concern there is less about the activity itself and more about the possibility of large numbers of people being introduced where they currently aren't. Just wondering if you've turned your mind to limits that could potentially be applied to those activities, gross floor area limits, employee limits, etc., and whether that might be one mechanism to address that risk introduced by more people being
Sure.
brought into the environment?
Sure, and look, it's something I'd be keen to take some advice from Ms. Pollich on as well in terms of the effectiveness of that.
Yep.
And I think there is that broader just uncertainty around the exact nature of development, and it's a cumulative
yeah.
issue. So that's where it can become a bit harder to keep track of a population number, because again, you can have, I mean, I think the COVID experience has been quite telling in that space. You can have a big floor plate with only a few people in there, or you can have quite a small space with a large number of people. You can have a very diverse range of office type activities. You could have a call centre with a number of people in there 24/7 versus a more industrial style office environment with fewer people on a intermittent basis. So there's probably some merit in giving some thought to that, but I'm not sure it necessarily addresses the issue around the population numbers.
Okay, thank you. And you would have heard the questions that I asked Ms. Pollich before, that I also foreshadowed to yourself and others about the concept of a dual contour or a multi-contour arrangement with different activities in it. Just initial thoughts on that as a potential option worth pursuing?
Look, I agree that it's an option that's worth exploring.
Okay. I was also wondering whether you've had a chance to reflect on the specific temporary activities rule that Mr. Wesney's recommended in his rebuttal.
Yes, and I think it's fallen into an interesting space, because the fuel companies did actually have some submission points on the temporary activity provisions, which is where we picked up on the risk management approach around those types of provisions. They haven't come through as part of this hearing stream. And so it was, I guess, a bit unexpected for us to see this issue come up now. So it wasn't one that we'd addressed in evidence. But yeah, in saying that, I think it is the appropriate time. We've got the risk experts in the room. I think it's the time to have the discussion. The approach taken by the fuel companies in that temporary activities submission was a restricted discretionary status for all temporary activities across the marina zone as a whole, and that was very much based on the need to manage population numbers and understand what an emergency plan would be and how you might get large numbers of people to exit that area in an emergency scenario, and just really about having that conversation, having the ability to consider the issues at the time when there's knowledge of exactly what is proposed.
Yes.
So that an appropriate response can be developed, but also that if that proposal really does go beyond the scope of acceptability and what could be managed at an acceptable level, then there is the ability to decline
Yes.
an application for it.
Okay, so it sounds like that would be a useful topic to add to the agenda for conferencing. Just wanted to ask a factual question about the recent realignment of the wharf line. You've noted in your evidence the example at Wiri where there's a designation in place for Wiri Services for the pipeline there. When the wharf line upgrade was being considered in the early planning stages, was a designation considered as a potential option there?
I actually wasn't involved at those very
Okay.
early stages, so I'm not aware if it was discussed or not, or any reasons for making a decision to not seek to designate it.
Okay. Might be something that Mr. Enright could get a factual response on and add to his submissions when he comes back to us.
Unless you know.
Yeah, I was going to ask similar questions about heavy thought designation, but who's the requiring authority? Have you actually got requiring authority status to do this by designation, whereas other agencies?
Yes, there would be an ability to obtain requiring authority status in relation to a fuels pipeline. It would potentially be complicated in this instance. It's a joint industry pipeline, so it's owned by the three fuel companies and operated by Nozzle. So there'd potentially be there'd be a process to work through in terms of understanding who would have that role.
And you'd have to seek requiring authority status as well. And that is in itself a bit of a process.
Yep. I do note in that context, in that Auckland context, whether, yes, the pipeline is designated, but there is also that pipeline corridor that extends beyond the boundaries of the designation. So the pipeline, I believe the pipeline corridor is 6 metres either side of, the designation is 6 metres either side of the centre line of the pipe. And then the management corridor goes another 34 metres beyond the edge of the designation. So a total of 40 metres either side, which is what we've sought in this context.
That's helpful, thank you. Just wanted to ask you about paragraph 819 of your evidence. And I was reading that paragraph with a great sense of anticipation for how it was going to end, and it doesn't appear that there is an ending there. I was just going to give you the opportunity to reflect on that last sentence and maybe complete it. This is evidence in chief 819.
Yes, I see it ends with a comma.
Top of 21.
So I think where I was going with that, my apologies for having tailed off that sentence.
That's okay.
The issue was about an avoidance approach. And my thinking around that was, if you can demonstrate that the risk and reverse sensitivity effects can be appropriately managed, then there would be avoidance of the reverse sensitivity effect. So
which you come on to in 820, yeah.
Yeah, so my thinking around that is perhaps a little different to Mr. Wesney.
Yes.
In that I would interpret, I wouldn't say that a requirement to avoid risk means that you can't take any
Yes.
risk mitigation measures. I would say that's very much a part of the expectation that to achieve a situation where you have avoided the risk, then you've adopted various risk mitigation measures along the way.
Yes. In that way, you could potentially summarize it as avoiding the risk rather than the activity that might have the risk.
Yes.
Okay.
Yes. And that's my experience of how that has been interpreted in various other documents, particularly under the NZCPS and some of the avoidance policies for Indigenous biodiversity in particular.
Thank you. I'm interested, though, as well in that same context. That paragraphs 323 and 328 of Mr. Wesney's rebuttal, his view is that minimize better aligns with the graduated and effects-based approach to managing risk under HIPAP. What are your thoughts on that?
So I take that to be that Mr. Wesney is acknowledging that in that definition of sensitive activities, there is ranges from that very high level of sensitivity under the HIPAP guidance, which is aged care facilities, hospitals, education facilities, including residential activities, which sit in a different category, and the office activities, which again sit at a lower threshold in terms of the HIPAP guidance, whereas they're all wrapped into one in this definition in the plan. Again, though, to my mind, I think it comes back to that issue of to what extent can those mitigation measures be taken into account in achieving that avoidance. And my approach to that would very much be that, yes, you can absolutely take into account the measures that a particular development might adopt to reach a point of concluding that the reverse sensitivity effect has been appropriately avoided. And that might be a control on localised population numbers or avoiding a building design which avoids a plate glass window facing towards the source of the risk, having appropriate emergency exits that take the population away from the source of the risk. So I would say there'll be a number of measures that a development should be adopting, and that may or may not get it to a point of being able to say that it can avoid risk, but I think that's certainly an available pathway.
Thank you. I'm going to speak on behalf of the panel here, but really I should probably just be speaking about my own understanding of the evidence. I feel like we have an excellent understanding about risk and the effects on the environment of the activities. I feel like the evidence is quite clear on that. What I'm less clear on is the particularities of the terminals on the wharf line and the effects that they generate, and the reverse sensitivities that may arise on those specific facilities. I feel like that might be something we could benefit from some more detail on. I think maybe in an urban-rural interface, the sensitivities are well understood, they're well known, but this feels a little bit different. And I guess I'd be interested if you have an immediate response, and if not, one to reflect on when you come back to the panel. Really drilling down into what those sensitivities are and whether there's any nuance from the terminals and the wharf line in that respect.
Sure.
So if you have any immediate thoughts, I welcome them.
Sure. Well, I think we would probably take advantage of your offer to come back to you.
Okay, sounds
but
good.
I would say it's those at a high level. It's going to be those issues around the operational constraints and the fact that if there's a new sensitive receiver in close proximity to the terminal, it's going to constrain operational flexibility.
And this is through the, say, a WorkSafe review. That's one of the avenues that's been presented to
Yes.
us.
Yes, so I think there's a number of triggers, and we can come back to you on
Thank
that.
you.
But yeah, there is potential for an upgrade in the activity,
Yes.
the facility status under the
Yes.
MHF regulations that would
Yes.
then bring down a suite of new obligations on the facility in terms of their management and reporting requirements. Restricts their operational flexibility around potentially switching out the product in one tank versus another, if that was to significantly alter the modelled risk contours and there was a sensitive activity right up to the
Nearby.
boundary of what was based on a model at a particular point in time.
Yes. Okay, that's helpful. I do think the panel would benefit from a clear index, if you like. And again, if there's any subtleties between the wharf line and the terminals, I think that would be really helpful to understand. I think there's just maybe one more thing I wanted to ask you about. Nope, that's all. Thank you for that.
Thank you.
David? Yeah, I don't have anything else. I wanted to, actually, talking about this whole designation, you said in Auckland that there's a designation for the pipeline in Auckland? Who's the requiring authority? Is it
So there are two pipelines in Auckland.
Yeah,
There's the pipeline that comes from Marsden Point down to the Wazzel terminal.
yes,
That one's operated by Channel Infrastructure, and they're the requiring authority for that pipeline. Then there's a second pipeline that runs between the Wazzel terminal and the Auckland Airport, and that conveys just jet fuel
yeah.
continually. And the requiring authority for that pipeline is Wazzel Warrior Oil Services Limited.
Okay, but no such entity exists in the CBU situation?
Not that I'm aware of, no.
Yeah, because there is some similarities with gas pipelines as well. In the hearings I've been involved with over the years, you often get whatever the current name of the gas operations is, it's Claris, I think, looking for similar sort of protection mechanisms in relation to their own pipelines. And that's been pretty well established. So what I think we'll do is we'll have a discussion about scoping conferencing. If you can provide that information through Mr. Enright that Commissioner Jones was referring to, that will be hugely helpful, and possibly in advance of the conferencing as well. I'd like to say we are under time pressures, but we realise we need to get this right as well. And there are, we're obviously hearing from the Marina next as well about what the potential solutions may be from their perspective, as well as needing to round back to the officers in terms of what they've heard as well. So it's relatively complex. I would expect we'll be looking to get a minute out, be early next week, scoping what the boundaries are of the conferencing, if that's helpful. Thank you for your evidence, well put together and well thought through. I don't have anything else specific myself, so thank you for that.
Thank you.
Back.
Thank you, Mr. Chair. So that's the presentation for your companies. Just for clarity, my understanding is the legal submissions by end of next week would deal with the plan stop question, just provide you with copies of cases requested. I understand you don't require legal submissions or planning evidence on the designation of the wharf line point, but it may be the subject of caucusing. Obviously, the point here, as Ms. McPherson well put, was rightly or wrongly, the wharf line is not designated, but in any event, if it was designated, that wouldn't deal with the corridor issues outside the pipeline itself. And so we are looking for a planning solution through the PDP process, but certainly that we'd welcome that being caucused by the planners, and we will provide Ms. McPherson will provide as an addendum to my legal submission next week, just the index of reverse sensitivity activity examples that was requested. I understand that's our homework.
Yeah, but pretty much in a nutshell, I'd only comment in relation to the designation that it would be potentially a tool available to designate the corridor, just not the pipeline. And that's but then you'd have to take financial responsibility.
That's right. Certainly it would be for another day too, because obviously that is not going to happen quickly with the complexities as you've heard. But if you require evidence on that, we'd be most happy to oblige. But otherwise, we'll leave that for the caucusing, as you've indicated.
Yeah, no, I think that's a good approach, and we might develop some further thinking where the parties to this particular issue can assist us on over the next day or two, but we will be looking to get some sort of scope out as soon as we can next week.
Thank you, Sarah. And on behalf of the fuel companies, just like to express our gratitude for the time you've given us today on an important issue. Thank you.
No, that's fine. I gather Commissioner Jones is one. Oh, sorry. Yeah. Well, I thought because you were jumping in between the two anyway. Okay. All right. We have some further questions of you. Sorry to go back, and that's in relation to the zone-based evidence as well. I personally, yeah. I will. Where you go, Jason?
Sorry about that. I was focused on your marina and hazardous substance at brief, and then just wanted to go back to your zone-based brief.
Sure.
Yeah.
And I only had one question. It's in relation to the definition about minor buildings or structures at the bottom of page 29 of your evidence. So starting from around paragraph 1033.
Yes, okay.
Okay. Mr. Davis has signalled in rebuttal that he agrees that a definition will be useful, and I think in the main it reflects the text that you've proposed. I asked Mr. Davis yesterday about subclause 3, which includes a height parameter. And then I also looked at the two rules which you've referred to in in the actual body of the paragraph there, which are MCZR5 and CCZR5. And in both cases, those rules which relate to minor buildings and structures require compliance with the building height standard, which is a different figure to that 5-meter limit. So the question I put to Mr. Davis, which I'll put to you, is do we need both? Could we perhaps rationalize those and avoid some confusion?
Yes, I'd certainly support that approach of rationalising.
If you could reflect on that, I don't need a response immediately, but if you have a suggestion about how that could be rationalised, given that this issue is particular to you and Mr. Davis, I'm happy for you just to informally report on that, and it could be something that Mr. Davis comes back to and reply.
Okay, that sounds.
Thank you.
Yeah, be good. Happy to do that.
Thank you, Mr. Chair.
David?
Ms. McPherson, I'm very conscious of time. Did you have a summary on the zone-based matters as well, as in addition to your hazardous substances summary?
I can run through a few
It's just that I'm
things.
conscious you were reading from a prepared statement on the hazardous substances, and I wondered whether you'd done the same.
Oh, it wasn't actually prepared, it was just speaking to some points.
Well,
Gave the impression.
yeah, and be talking about the Seaview Marina Zone, which is in the other
Yes,
one as
it
well.
is.
So
I guess my question is, you've read the rebuttal from the 42A officer, and I've read your 42A and your evidence in chief, and you've moved on some of the matters like the servicing rule, and there's still some matters that you've identified in terms of the matters of discretion on that for the functional and operational matters, which seem to be addressed in some zones but not in others. And I just wondered, what sort of update have you got, having received the rebuttal evidence from the 42A officer, Mr. Davis?
Sure.
Has your position changed further, I guess, is what I'm asking. What are the live issues?
Yeah, well, I think in the context of the
This is mainly for the commercial zones I'm talking about.
yeah, sure. I think in terms of that scope issue that was raised on the functional operational need, there was one additional zone that I believe there is scope on, but otherwise the fuel company submissions had focused obviously on the zones that have service stations in them. It's not an intent to expand into new centres zones.
But on that servicing issue, you'd actually said that the change that was made in the commercial central city zone, the local centre zone and the light industrial zone hadn't been replicated in the metropolitan or the general industrial zones. In terms of the functional operational needs as a matter of discretion, that was your position in your evidence in chief.
Sorry, that it needed to be replicated.
You were pleased to see that the words have been added in respect to those three zones: central city, local centre, and light industrial. But you raised the question, why hadn't it been added to the metropolitan centre and the general industrial zone? And I just wondered whether the rebuttal from Mr. Davis on that had addressed that to your satisfaction.
No, I don't believe it changed my position on that.
Okay.
Apologies, I was focusing more on the hazardous substances
I mean,
provisions for
I
this
could go
presentation.
through a number of these. I could go through a number of these matters. I'm conscious of time.
Yeah.
That's just the servicing rule.
Yeah,
The development rules are largely broken into the active frontage and car parking for existing developments, the alts and adds in the metropolitan and central zones, and the minor building and structures rules and definition, which Commissioner Jones asked you about in terms of the definition. You've said in your evidence in chief that you're not pursuing the alts and additions changes in the metropolitan and central city, provided the changes are made to the frontages and car parking rules in all zones relating to minor changes. Is that still your position? Yes.
yes.
Okay. And you haven't seen anything in the rebuttal from because you haven't provided a rebuttal statement yourself, have you, Ron? No, and you haven't seen anything in Mr. Davis's rebuttal that would change your view on that? Okay.
No.
Okay, well, that's probably the simplest way for me to deal with that in terms of the commercial zones. It's those are still live issues for you.
Yes.
Okay, thank you.
Ms. McPherson, thanks. I just have a really quick question because conscious of time. At paragraph 10.15 of your evidence, commercial, where you're seeking exemptions for service stations from specific permitted activity standards, we talk about effects neutral works being captured. I was just wondering if you could elaborate on examples of what effects neutral works are, and are they and why they're only relevant to service stations?
I think the background to these submission points around changes at service stations is that we often go through consenting processes involving replacement of the underground fuel storage tanks. And at that time, quite frequently, the companies will look at increasing the capacity of the tanks, and it's mainly an efficiency approach, whereby that means less tanker deliveries to a site. So there's more fuel stored at the same time. In some cases, there'll be minor changes to the layout of the fuel pumps, but we frequently get a lot of pushback from councils with the assumption that these sorts of changes will mean a significant increase in vehicles coming to the site and requiring quite a high level of information around traffic generation, and it's simply not the situation in terms of how these types of sites work. They're primarily drop-by businesses, unlike, say, a supermarket or a destination activity. There are a few people that divert a route to go solely to a service station, and even fewer who would do that because they're aware that suddenly there's a 120,000 litre tank underground versus an 80,000 litre tank. So it's intended really to try and get us to a point that these sorts of what are considered by the fuel companies to be maintenance activities. Fuel tanks have reached the end of their life. They need to be renewed and replaced. The newest technology will be used at that time, but in terms of the ongoing effects of the service station activity, that remains unchanged. So I mean, I've been through processes of needing to go through appeal processes to get the council to accept that the existing environment is the existing environment, and it's only construction-related effects and an upgrade in the infrastructure at the site. So this is what sits behind where we're coming from, trying to carve out service stations from a retanking process being assessed as a completely new facility, and with a whole, needing to assess traffic effects essentially from scratch in terms of where the service station likely has grown and responded over time since it was first installed in response to changing traffic environments. And so this is, we're trying to carve out service stations because we do think there is a difference around these types of activities. I think obviously a full-scale renewal and increase in expansion would fall into a different category. It's really about providing a workable pathway for these types of retanking, routine upgrade and maintenance type activities that don't materially change the operation of the service station.
Thank you, Ms. McPherson. There is no further questions, so if you'd like, we'll move on to the next submitter. But thank you all for your time. It's taken a lot longer than any of us actually anticipated, but a very worthwhile discussion overall. Thank you.
Thank you.
Right. Just while the next submitter is coming along, Sarita and Nathan, Mr. Beeben coming at 1. Can we find out whether or not he might be able to come along a little later? Because I think we'll probably, I'd obviously like to hear from Seaview Marina and then take a break. Probably can be a relatively short break. But that will mean we might need to push Mr. Beeben out another, what do you think, half an hour or an hour? Say 1:30, can we see if he's all right with that? Thank you. Hello, welcome. Apologies for lateness. I think you were due to be on an hour and a quarter ago, but obviously important issues we're facing here. So who's sort of doing the intro and?
I propose that we go in the order of Tim from Seaview Marina will speak
Yep.
first, and then we'll go on to Rob, who's online, the hazardous substance expert, and then I'll go last. Does that
Yep,
sound-
that's fine.
We've each got a summary.
Yeah, we
Okay.
had, have to find it, we had some,
You won't
Two
have Tim's
summaries?
one, yeah, that from the experts.
one from you
Yeah,
and one from Mr. Van der Monkoff.
yeah, that's
Okay.
correct.
Thank you.
All right, I'll pass over to Tim.
Well, tēnā koutou katoa. My name's Tim Lidgard. I'm the Chief Executive with Seaview Marina. Thanks to the Chair and Commissioners for the opportunity to speak today. I'll preface this by saying that I'm not a planner or a technical expert. I'm here today with an impassioned plea on behalf of our stakeholders because I think it's important and I think it holds weight. I'll give you 60 seconds of background. Construction at Seaview Marina began in 1989 under the Wellington Harbour Board, and following the local government restructuring, ownership was transferred to Hutt City Council. In 2003, Seaview Marina was established as a CCO and a public benefit entity. Since then, Seaview Marina's mission has been to, quote, provide industry-leading facilities and services that delight customers and stimulate related economic activity, end quote. Every dollar of our earnings over the last 30 years has been reinvested to achieve that mission. So what is at stake for our stakeholders? Well, Hutt City Council is our sole shareholder and they're operating in a tightening financial environment. Seaview Marina is going to face pressure to generate higher returns with a real risk of divestment if financial performance remains modest. Our customers face uncertainty over ownership continuity and fee increases. The existential threat here is that the marina pricing will be forced higher, reducing occupancy and making necessary revenue thresholds impossible to achieve. Our commercial tenants are affected by divestment or repurposing of the Wellington Marine Centre because it affects their lease security and the marine trade ecosystem we've worked so hard to build. This will result in job losses and detriment to the Seaview Gracefield area. Our employees are also affected by divestment or repurposing as it will result in job losses and lasting damage to the Seaview or Gracefield community. And the wider community is affected by divestment or repurposing because it will mean they'll lose their stake in shaping the Lower Hutt waterfront for future generations. So it has been discussed, what is our vision? Well, our vision is, quote, we'd like to be renowned as a New Zealand leading marina that embraces the whole spectrum of services and boaties that water enthusiasts desire. Wellington Harbour unfortunately lacks sheltered destination anchorages. This results in lower vessel ownership per capita and insufficient scale to sustain a simple vessel storage and service business. In Wellington especially, marinas must innovate to create asset value. The modern marina customer is demanding more. What determines our market share now is our on-land offerings. Renowned marinas act as community hubs, offering services such as supermarkets, health clinics, wellness studios, galleries, non-marine essential retail, gymnasiums, professional services, such as financial and legal advisors, realtors, or engineering firms, to name a few. So what is our current status? Well, boating has become less affordable for the majority. In recent years, boaties have seen huge increased costs for electricity supply regulations, gas system compliance, insurance, marine biosecurity, travel regulations, and the increases for vessel storage and marine trade services. This all equates to a significantly increased cost of ownership. The Seaview Marina business is based on customers having discretionary income. With these increased costs, in conjunction with the wider cost of living crisis, this has resulted in occupancy levels at a 4-year low. 2020 through 2025 saw an average profit margin of 11%. The 5-year forecast from 2026 onward is for an average profit margin of 3%. Put simply, if Seaview Marina is overly restricted in how it develops new offerings, the business will die. In late 2023, Seaview Marina commissioned a land use feasibility analysis. Key findings of this study included that development of office space on site would provide a margin of cost of just over 8%, and a retail development would provide a margin on cost of over 20%. These returns demonstrate Seaview Marina's potential for revenue growth and asset value realisation, which is an urgent need for our stakeholders. Those development margins can fund rate relief or be directed to those in need. The vision, Seaview Gracefield 2030 Transforming the Future, is a past Hutt City Council vision document for the Seaview Gracefield area, which identifies that attractiveness as a work location depends on, quote, easily accessible social places where colleagues, clients and visitors can meet, and access to basic services, e.g. banking, pharmacy, post shops, end quote. Those are all precisely the services that constitute a modern marina hub. So what's the community's perception of Seaview Marina? Well, the Seaview Marina Community Perception Survey drew 629 responses, which is a clear signal of the community's interest in the marina. 83% agreed that the marina is an important community asset, describing it as valuable for recreation, hospitality, and an attractive waterfront destination. The striking finding was the gap between perceptions of the marina and the surrounding area. While 79% considered the marina safe, only 60% felt the surrounding area was safe, with written comments repeatedly citing boy races, antisocial behaviour, burglaries, poor lighting, rubbish and heavy industrial traffic. This highlights the broader issue. Barriers to visitation at Seaview Marina relate not to the marina, but to the surrounding area itself. A consistent theme was the desire for greater activation through events and activities, with comments like it would make an excellent festival location, or it could be a hub, more like the Viaduct in Auckland. The community clearly values Seaview Marina and sees substantial untapped potential. So what's the proof of concept here? Well, Wynyard Quarter, Central Waterfront in Auckland, Wellington Waterfront redevelopment, Dunedin Harbourside redevelopments are all examples of improving public access to the water, creating recreational and civic spaces, encouraging tourism and hospitality, increasing walking and cycling connectivity, and addressing climate adaptation and coastal resilience. These are not merely beautification initiatives, these are long-term urban regeneration and public wellbeing investments. So what is our legacy? Well, past and present Seaview Marina stakeholders consistently identify the need for greater safety and beautification in the Seaview Gracefield area. The New Zealand Police STEPTED guidelines use the built environment to make spaces safer, more visible and better used. Applying these principles to the Seaview Marina zone is a key tool for improving the surrounding area. A public and vibrant zone promotes eyes on the street, a form of informal surveillance. More business owners create territoriality through a feeling of ownership and investment in local assets. Well-designed entry points control access and reduce isolated areas, thereby improving safety. Finally, well-maintained areas, clean public spaces and maintained infrastructure are less likely to attract crime. The development of the Seaview Marina zone makes this far more achievable than the industrial status quo. So in closing, the vibrancy and visitation derived from Seaview Marina developments therefore play a critical role in driving economic benefits and directly addressing the identified safety gap. Accessible active spaces contribute to community well-being, resilience and safety. The Seaview Gracefield foreshore should be a place where people feel comfortable, connecting with each other and within the marine environment, a place for them to thrive. Events like 2 regional boat shows and a benefit concert have already delivered this community connection. Rock Around the Dock raised thousands for Wellington Coast Guard, with drone footage estimating attendance of around 500. Hundreds of millions have been invested in shared pathways, with the Seaview Marina Zone a potential drawcard along that route. The Remataka Cycle Trail, one of 23 great rides, is set to include Seaview Marina on its route, driving tourism and economic benefit for the area. Seaview Marina is an absolutely vital community node. The potential social and economic benefits within the zone are within the grasp of the people of Hutt City and the wider region. Overly restricting the Seaview Marina Zone's development is to deny our people this once-in-a-generation opportunity. Ngā mihi nui for your time and listening to me today, and I will be available for any marina-related questions. Thank you.
Wasn't quite the summary I was expecting. There was a lot which was in your 7-page evidence which you read out. But regardless of that, I'll just see whether 2 questions from Commissioner Jones.
Good afternoon. Thank you for your evidence and your presentation. As the chair just noted, I took it that you were drawing heavily on your pre-circulated material, but in the middle, under your discussion about the vision, you interpolated with some financial figures. I was wondering if you could just provide a copy of that so that we have that handy. That'd be helpful.
Yes, can do. Thank you.
And then also, I just wanted to ask about the employees of the marina. You've noted they're one of your key stakeholders for obvious reasons. How many employees does the marina have at present?
At present, there are 7 direct employees, forecast for 9 next financial year.
Thank you. So, Mr. Chair, thanks for that.
The only question I have is in relation to your comparison of Seaview to Dunedin Marina, Wynyard, Wellington. I presume you mean Chaffers and Wellington, and the relationship that there is of each of those marinas to the rest, if you like, the central city activities that there are. I'm struggling to see that there's a direct correlation with Seaview in relation to where it sits amongst its neighbours, as there is to Wynyard, Dunedin and Wellington CBD. You want any comment on that?
I think that's a fair comment. I think it relates to strategic vision around what Hutt City Council are looking for out of its foreshore. Certainly, in the case of Wynyard Quarter, there used to be bulk storage facilities for fuel everywhere there. So I think when you look out into the future, which is why I'm sitting here at this table, it's about what the future of that area could look like.
Okay, thank you. Got no further questions. Mr. van der Munkhoff.
Good afternoon. Can you all hear me okay?
Yes, we can. Thank you.
Cool. Thank you so much. Look, I think you have got a pre-circulated summary, and I've also been listening in, so I've heard some of the comments. So I probably won't go through it word for word, if that's okay, and we'll just kind of jump through some of the key matters.
Very good. Thank you.
So first of all, I'll jump to paragraph 5 of my summary statement. I guess just here, I just really want to highlight that the approach that's proposed in the district plan has been used elsewhere in the country. It's an approach that has been demonstrated to work well, and generally, obviously, I don't have any concerns and support the use of the approach. But in terms of the approach, and I think we've had some previous discussions that have had. The question comes down to just that, how that approach is applied. And it comes through a couple of key matters that really relate to those, and there's kind of a bit of a chicken and egg situation between those 2 matters. The first one is whether or not you've got the appropriate risk criteria in the first place for determining what is unacceptable risk or unacceptable residual risk in terms of the provisions in the plan. And the second piece being, well, what do we call those activities that are sensitive to that risk? I think the plan as proposed has applied the proposed 1 in a million risk criteria for setting what's, I guess, an acceptable level of risk. I know that has been used for a variety of different district plans previously in determining what was an appropriate criteria. In terms of that, and we've got some obviously evidence from the fuel companies, including Ms. Pollock, about the question between the 1 in a million and 0.5 a million. I think when you look at the two, it comes down to those definitions of sensitive activities, and I think I highlight that as we move through. So the 0.5 in a million risk criteria is really designed for those highly sensitive activities. So things like childcare centres, hospitals, and the type of activities where you have got a reasonable sized population present, but that population is also difficult to evacuate. You can imagine trying to evacuate a hospital in the event of a fire and incident is quite different and quite challenging compared to an activity such as an office or a commercial type activity. So I think when you look at the two in terms of the risk criteria, it's a question about, is it a matter of what the number is, or is it a matter of making sure the definition of activities that are sensitive is correct? And I think you could choose either of those tools and look at making sure the definition is right. And if that definition is right for the activities you want to control, applying a 0.5 in a million contour in terms of that overlay may be less of an issue. Conversely, if you apply a kind of a more conservative, less conservative number, such as the 1 in a million, you might want to make sure your definition is a bit tighter. So I think there's a question back and forth there around making it really clear around what are we trying to control, what is appropriate to be managed in this environment. In my opinion, when we look at the marina site and what we've got, I'm pretty comfortable that the 1 in a million is appropriate, and that obviously that being a criteria for managing risk. And that would mean that there wouldn't be controls on those less sensitive activities. And we've already got that with industrial, commercial, and offices in that same classification of those less sensitive activities. And I say that because they're all centralised. They can, they've got easy evacuation. For the evacuating office buildings, you've got mobile people, a centralised point of control. In the event of an incident, the ability to evacuate those people safely is relatively simple. So if the 1 in a million is to remain, I don't have any concerns with that being an overlay. I also probably don't have any concerns with a 0.5 in a million being used in the overlay, as long as that definition is correct. One of the areas that does fall in a little bit in the cracks between the two is residential activities. And I'm probably not in disagreement with Ms. Pollock that can have an impact on the societal risk. Depending on what the sensitivity is, kind of density of that residential activities. We know offices, more dense residential, such as apartments or mixed use type activities where you've got larger numbers of residents on site. That does create that challenge around evacuating. It does make it a little bit more challenging in terms of evacuating a large number of people or a large number of residents across different areas. They don't have the same central control, the ability to evacuate. So in terms of that, I think it probably sits in a little bit of grey area, which I've outlined in my primary evidence. So I think it probably doesn't necessarily say it's not on surface immediately inappropriate, but it does mean that there needs to be some consideration around how you would manage those risks. Can they be managed, and what level of development is appropriate within that area? So it's a question around what level of development and how do you bring those controls in. And I noticed the fuel companies also discussed a little bit of that just in their previous session around looking at some of those controls that can be implemented in terms of developments. So that means that it's not saying it's necessarily inappropriate, but that you would need to assess and make that decision on a case-by-case basis. Lastly, in terms of occasional irregular activities, so the key issue or the key risks associated with the fuel pipelines and the facilities is primarily when the pipeline is getting pumped. So when there's fuel coming and going. So when there isn't any fueling activities, what I'm looking at there is there an ability to have a framework that allows the fuel companies and the Seaview Marina to look at their schedules, look at their programs, and if it can be fitted in within those two, that there's actually a process or a rule framework that enables activities to be undertaken. So that may not be a regular market, that may not be something that is viable, but there may be those occasional events, summer sailing events, those type of activities that you do see in the marina type environments, that if they can be scheduled between the fuel company's requirements and the marina's requirements, that there should be a framework that enables that to happen. At the moment, that's not the case, and would make those activities very difficult under the existing framework. Finally, in terms of the fuel pipeline, I think both Ms. Pollock and myself are referring to the same guidance and really are probably applying the same guidance in the same manner, which is the guidance, is really clear around making sure that you do manage those sensitive activities adjacent to the fuel pipelines. And again, the guidance when we're talking about sensitive activities are those more sensitive activities, so hospitals and schools, and not necessarily talking about those less sensitive activities such as office and commercial activities. So I think if there was an overlay that was applied, again, it comes down to that definition of those activities that are controlled by the pipeline versus those activities that are enabled. So if the argument is an overlay is required, I'd consider that would need to be really considered. And the definition for sensitive activities may not be the same for the pipeline than it is for the bulk fuel terminals. And I guess in terms of that, there's a broader question that sits there, and I'll leave that for Alice a little bit more when she talks later. We look at a lot of these rules in isolation, and I just want to highlight that the rules aren't in isolation. We are in an industrial zone more broadly, so a lot of these sensitive activities are already controlled and managed through other plan rules. So I guess in terms of good planning, I do think that there's a need to make sure that from a hazardous substances perspective, we're not highlighting or implementing rules and controls that are already restricted elsewhere in the plan and managed through other provisions. So making sure that we are thinking about those activities that are likely to establish within both the Seaview Marina and the adjacent zones, and making sure that any overlays and definitions and rules are appropriate for those activities. And that's the end of my summary. Happy to take any questions.
Thank you for that. Questions, Matt? Jason will go first.
Good afternoon. Thank you for your evidence. Commissioner Jones here. I've just got a couple of questions because I'm mindful that we have, well, firstly, we've asked Ms. Pollock if she's available to confer. Are you happy to assist the panel further with some technical conferencing with her as well?
Yes, I'd be happy to do conferencing with Ms. Pollock.
Great, thank you. On that basis, I think I can probably pull back quite a few of the questions that I had. One of the things I wanted to ask you was about Mr. Tinley's statement. Did you have the opportunity to read that before today or today?
I've had a quick look over it. I'll be honest, I haven't had a detailed review, but I have had a quick look at it, yes.
You may have heard me ask Mr. Tinley before about the best practice measures that have been adopted at Seaview, and I believe from your original evidence you'd sort of questioned the detail there. Has Mr. Tinley addressed any of those information gaps for you to your satisfaction, or do you think there's still some more detail required?
Yeah, so the question was, I guess, was more in relation to the QRA that's been used as the basis for setting the overlays. Yeah. That obviously was prepared a number of years ago, and I know there's an updated version. And I guess the comment was it is not clear from the QRA that was made available whether or not those measures had been considered in terms of the risk the QRA work, and whether or not the incorporation of those measures or the inclusion of those measures in the QRA would change the extent of the contours.
Yes.
So that related to the point that if we are going to put contours in the plan, we need to make sure that they reflect the most up-to-date and correct information.
Yes.
And one of the key factors, obviously when we look at the risk, and obviously he did a really good description on the Buncefield scenario, which is the scenario that really drives the biggest risk. In terms of that, the key issue there was the amount of time it took between the overfilling to occur and that to be kind of identified and captured, which then impacts on the size and extent of the vapor cloud. The QRA takes a pretty precautious approach at the moment of applying a 30-minute time frame before, in terms of any controls put in place. So I guess my question was more whether or not those additional safety measures that are included, vapor detection, automatic shut-off and stuff, obviously have they been accounted for in terms of that time in which any overfilling would be identified or avoided, and did that have an impact on the extent of the risk contours and the QRA outputs? So less about concerned about whether or not the controls are applied, but whether or not those were incorporated and have been considered in the QRA.
Does that remain an open question for you?
I think it does remain an open question. I know in just initial discussions with Ms. Pollock that the QRA was being updated, but that has not been provided at the time. Obviously, in time for the hearing.
Okay, I think it'd be useful to hear from you and Ms. Pollock on that when you come back to the panel. So I'll softly put that onto the agenda now. I think probably the rest can be dealt with through our directions to you. So I can probably leave it there for now, Mr. Chair. Thank you for your evidence, Mr. Van Bronckhorst.
Thank you, sir. It's Commissioner McMahon here, and I'll be similarly brief, conscious of time. Just on that last point from Mr. Commissioner Jones, I think it would be important that this witness is provided with the updated QAR prior to any conferencing, if that's possible. Yeah. Just stepping back a little bit, two matters from me. First, in terms of which overlay is appropriate, you talked about the difference between the 1 million and the 0.5 in a million, and what I recorded is that either is okay, so long as if you adopt the more conservative one, that would probably result in a change of the definition of sensitive activities. Have I recorded that correctly?
That's correct, yes.
And and I don't really want to put you on the spot because I know you're going to be partaking in conferencing, but based on the context of this location and acknowledging your comment that the residential component of sensitive activities is largely the determinant of which is more appropriate, do you have a preliminary preference for either approach?
I guess the residential in terms of this location is probably a matter that would need to be considered, and I say that not just in terms of hazardous substances. There's a whole pile of other issues that are also relevant to the presence of residential at the site. But I can I think there's parts of the marina, if we just look at hazardous substances by itself, that is definitely acceptable, appropriate for residential activities. And I think as identified in Ms. Pollock's supplementary statement, there's some areas where the risk is probably tipping more the other side of a little bit harder to be able to demonstrate that the risk can be managed. So I think in terms of residential, it's definitely a granularity, not just in terms of, application of residential, but even across the site. And then it comes down to that question of what level of density of residential, what level of controls and management you put in place. So if we're talking relatively, low density, a couple of, some townhouses type development where your population may be increased, obviously a small amount, but not inconsistent with other residential areas in the neighbourhood, you probably wouldn't, the level of risk or the acceptability of that risk is probably, higher. If you're going to put a a 6 or 8 story apartment block or a hotel there, you're probably tipping a little bit more to that risk is unacceptable. But I think that's where having a framework or provisions that allow for that evaluation and assessment of that risk is, obviously would provide for that and enable those activities to be evaluated against the policies in more detail.
Yeah. Okay. Well, that's quite nicely sidestepped, and I won't push you any further on that in advance of the caucusing that's to be undertaken. And my knowledge on this topic is very generic. So my last question is, there was some reference to the AUP model, which has an inner and outer contour. And I'm just picking up on what Ms. McPherson talked about. Firstly, are you familiar with the AUP situation?
I'm aware of aspects of it in general. I wouldn't be over the full detail of it, but I'm aware of the approach of how they've managed the kind of the different levels of risk and the different contours to manage those. Yes.
And subject to questions of scope, is that something that might be explored here, in your view, from a technical perspective?
Yeah, I think having multiple I don't have any concerns or any technical issues with having multiple overlays, and those overlays, specifically dealing with slightly different levels of risk associated with each of those. Yeah, so.
Yes.
Yeah.
The way I heard it explained today was that the inner relay was more of a design sort of construct, whereas the outer one was more about emergency planning responses.
That's correct, and I've obviously been involved in a lot of some of the emergency management works at Wynyard Quarter as well, and I know Ms. Pollock was. We did conferencing in relation to that, and that was very much around how do you manage evacuation events, how do you manage those type of circumstances. So if you are holding public events or you've got intensification as you look through, and Wynyard Quarter was a really interesting example where intensification happened prior to obviously the hazards moving out, and that is being managed, and there's still residual hazards there with the Sea Lord site, but that is managed through emergency evacuation procedures and controls, and it doesn't necessarily kind of say that activity by itself is inappropriate just by being there.
Sure. Look, I'll leave it there, but I just want to signal that might be a topic that might feature in the direction on the conferencing. We're yet to finalise that. But thank you, Mr. van der Munkhoff.
Thank you, Mr. van der Munkhoff. I have no additional questions. I'm also very interested in what's in the list of sensitive activities and what isn't, and how it might apply to the spatial configuration of the Seaview Marina site. So thank you for your evidence. Ms. Blackwell, finally.
Good afternoon. So I've just got a brief statement that you should have a copy of. I'm just going to read out. My name is Alice Jane Blackwell. I provided a primary statement of evidence in support of the submission from Seaview Marina for hearing stream 2, business date 8th of May, and rebuttal evidence dated 20th of May. My qualifications, experience and commitment to complying with the expert witness code of conduct are set out in my primary statement of evidence. Since the submission of my primary statement of evidence and rebuttal evidence, I have read the relevant sections of the 42A rebuttal reports, Jenny Pollock's rebuttal evidence, and Rob Enright's legal submission. And I just raise a few of the key outstanding issues. Is the Seaview Marina infrastructure? I remain of the view that Seaview Marina is infrastructure as defined under Section 2 of the RMA, and therefore the enabling provisions of the National Policy Statement for Infrastructure are relevant to the marina. In respect of the definition of infrastructure, I agree that a fine-grained analysis of the Seaview Marina facilities may be warranted to identify the specific aspects of the marina that directly relate to the facilities for the loading and unloading of cargo or passengers carried by sea. Now, I've just corrected this, having rechecked Section 2 of the Act, that only the transmission pipeline is defined as infrastructure, but the bulk fuel storage terminal and the pipeline are regionally significant infrastructure under the RPS. Definition of activity sensitive to hazardous substance risk. In my opinion, the definition of activity sensitive to hazardous substance risk should not include office activity other than ancillary to an activity that is not an activity sensitive to hazardous substance risk. Informed by the evidence of Mr. Van der Munkhoff, office under the HIPAP 4 guidance would be subject to a less stringent criterion, being the 5 in a million risk criterion. As outlined in my primary evidence, I understand that the 5 in a million risk criterion for office sits almost entirely within the fuel terminal site, and therefore I consider that office should be excluded from the definition of activity sensitive to hazardous substance risk. Reverse sensitivity and hazardous substance risk. Hazardous substance risk is a health and safety issue. Provided the 3 criteria reproduced below from Mr. Van der Munkhoff's evidence are satisfied, it is appropriate for the plan to direct that hazardous substance risk is avoided. And those 3 criteria are that the appropriate risk criteria being applied, that the risk criteria being applied to the correct land uses, and where a mapped overlay is included is an accurate reflection of the extent of the risks. Reverse sensitivity is a relevant planning issue, but in my view is different to hazardous substance risk. Reverse sensitivity is also broader than hazardous substances. I agree with the hazardous substances section 42A officer's rebuttal evidence relating to reverse sensitivity and consider this reasoning is equally applicable in the Seaview Marina Zone chapter. At paragraph 3.24, reverse sensitivity is context specific and can be effectively managed through design, layout, operational controls and consent considerations. An avoid directive would introduce an absolute policy threshold, potentially constraining otherwise compatible development and limiting the ability to address effects through site-specific mitigation. In my view, an avoid district plan provision with no qualifier is overly restrictive on future activities within the Seaview Marina Zone. The fuel transmission pipeline corridor. I consider that construction activities, including in relation to the construction of underground services that are in close proximity to the pipeline corridor, should be managed by the proposed district plan. But I consider this to be an issue of hazardous substance risk rather than reverse sensitivity. I know there have been some questions about that today. I'm also not clear what the reverse sensitivity issue is of an underground pipe. So would welcome some more information on that from the fuel companies. And in relation to the hazardous substance risk management overlay, I'm not opposed to there being some sort of mapped outline in the plan where the pipeline is. But at this stage, I don't think we have the evidence that the pipeline as proposed in the fuel company submission is right and is fit for purpose. So until we actually can understand what, there's no QRA, not really sure on what the reverse sensitivity issues are. So I do think there needs to be some sort of management, particularly in relation to construction, but I don't think it's the same overlay with necessarily the same activities that would be applicable at the terminal. In relation to the Seaview Marina Zone provisions, some key aspects from here. My evidence sought a broader definition of marina activities and just fundamentally a simplification of the provisions. So haven't gone into detail of all the different things, but the submission sought a number of changes just to make the provisions simpler. And now I welcome questions from the panel.
Thank you, Ms. Blackwell. You've obviously sat through this morning, and I think that's probably been helpful that you have, because we will be requesting conferencing, which you'll be part of as well. I've only got one specific question, and I know my colleagues probably have a number of others, but in terms of whether the entire marina is infrastructure in terms of Section 2, Have you seen the legal opinion attached to the rebuttal evidence of
Yes, yes, I
Mr.
have seen
Davis?
that. That was what I was referring to in my summary statement, that finer grain analysis. I agree that that would be warranted and that there may be parts of the marina that wouldn't be considered infrastructure, but I do think that there are parts that are.
Yeah, just looking at the operations of the marina itself. Obviously got the boat ramp and you've got the boat mooring areas, and then there's quite a bit of parking available as well. It'd be interesting to drill down a little bit more in conferencing as to why you feel that this is infrastructure, as opposed to servicing for boat users and so forth, the marine activities. I'll be interested to see where you get to on that, and it's likely we'll have a specific question which will require a response in terms of a joint witness statement. Matt? Okay, Jason's probably got several.
Thank you very much for your considered evidence and for your presentation today, Ms. Blackwell. I think you've picked up on the themes of some of the questions I've already been asking, and I probably don't need to labour it any more than I have. I think you're clear based on what you've interpolated to us just now, where we're thinking things might need to go, and we'll make that clear in our directions, I think, on the minute. I just wanted to put to you, or give you the same opportunity that I put to the fuel company's experts this morning, and Commissioner McMahon just put to Mr. van der Monkoff about the notion of a more nuanced approach using different spatial tools and a different mix of activities. Is that something that you're open to considering? Do you think there's potentially some merit in looking into that as part of your discussions with your contemporaries?
Absolutely, I think there's merit in that. You would have seen in the rebuttal evidence from the fuel company's hazardous substance expert, even that has some sort of more detailed fine grain where intensification in terms of population wouldn't be acceptable, but over on that side of the site it would. So I think that that would be a good thing to investigate.
Thank you. And you might have heard my question of Ms. Pollock about office activities, and she addressed that issue by saying that office activities, while having that lower risk sensitivity in the HIPAP guidance, the issue that she had was in relation to the size of the office and the number of people who might be involved, and therefore the difficulty that would be increased with more people being in the office. Do you think it's potentially an option that the provisions look at how the scale of office activity could be managed?
Absolutely, yeah. That's something that I have discussed with Rob van der Monkoff. In trying to understand the QRA, there's a section, there's the contours, but there's another part of that report that talks about societal risk with the graph, and probably something that I'd need technical input into, but as I understand it, office was still within the acceptable threshold. But take the point that if it was some sort of intense office or had a certain threshold of people, it would make sense that was something that was up for consideration.
Yes, and I understood from Mr. van der Monkoff responding to Ms. Pollitt about the granularity that's involved, and that included both the activities themselves, but also the spatial orientation. So I take it that's something that you'd factor into your, to how those different activity mixes and limits might be applied. They also might have a spatial context.
Yeah, so the combination of the activities, as well as the population density, yeah.
Just check my other notes. Now, I understood from your original evidence that you were promoting a permitted regime for the market-based activities. Do I understand from your rebuttal that you're looking at that more from a managed point of view, perhaps through a consent process? Do you think that is that where you've moved to in your mind, or do you still think it could be dealt with
I was
through?
perhaps distinguishing between the hazardous substances rules
Yes.
and managing in that overlay as opposed to, so in the hazardous substance context, if there's an event with a lot of people, it's worth there being some sort of process to make sure that, the fuel companies are lined up with the Seaview Marina, and B, there's, the right controls in terms of evacuation and emergency management procedures.
Yes.
But I would still leave it as permitted under the Seaview Marina Zone
rules.
provisions and just leave that as something to be managed in the hazardous substances chapter. So perhaps not that it's moved, but more that I thought it was appropriate to consider that issue in hazardous substances.
Thank you. I think probably the rest of my questions will be relevant to how we frame the directions on the conferencing. So thank you very much for that.
Good afternoon, Ms. Blackwell. I've got two questions on the Seaview Marina Zone provisions. But before I ask them, and indeed if I do ask them, I couldn't recall whether your rebuttal had addressed those or whether it had focused solely on the hazardous substances and contamination.
I'm pretty sure it just focused on.
Yeah.
Oh, there was a little bit in terms of the change in the activity status of the rules of the Seaview Marina Zone, but it was in response to the fuel company's evidence.
Yeah, I completely missed that. But you've answered my first question, that you've seen the rebuttal of Mr. Davis on the zoning matters.
Yes.
Yes. Okay. And you're still requesting a broader definition of the marina activities and a simplification of the zone provisions. And in the latter matter, you're directing us to the original submission, which contains the details of those changes.
The original submission from, I've attached a
You've got a schedule
track changed version to my primary evidence.
Yes. Okay. And we should rely on that.
Yes.
Okay. Thank you.
Thank you. That's the end of the questions that we have for you. As you probably have heard, we were getting some directions out hopefully early next week in terms of next steps, but thank you very much for your participation and the effort that's gone into preparing your material. It's been most useful. I think we'll have a shortish break for lunch until 1:30. And then we'll hear from you, Mr. Davis, after that to complete what we started yesterday afternoon.
Do we have a time that Mr. Beevan's appearing for Mauria Community House?
Okay, so quick bite and then back here. Thank you. Good afternoon. We'll recommence hearing stream 2 of the Hutt City proposed district plan. And we have Mr. Bevan. Now, thank you for your indulgence and being flexible. We this morning went well over time from what we originally anticipated, so I do thank you for being able to come along at relatively short notice to appear at a different time.
Well, firstly, thank you for accommodating my change from yesterday, so it cuts both ways, so I do appreciate that. I'm not presenting any new evidence. I haven't got a written summary of statements. Essentially, everything I needed to outline was outlined in my evidence, and I've got nothing further to add to that, aside from probably just noting I'm here to speak in my role as the Community House Chair, so it is their submission as opposed to an urban edge planning submission. And the submission point is very simple. It's just, is the mixed-use zone the appropriate zone for essentially what is a pocket park with a few community facilities on it? And it was within the submission, it was suggested that the sports and active recreation zone may be a more appropriate zone, just given what the objectives and the intent for what that zone is seeking to achieve. Though within my evidence, as I wasn't involved in that submission, I picked up that open space would have been also a candidate, though noting that our submission or the submission from the Community House didn't note that, so such a request was out of scope. And just really here to take any questions that there was around the evidence. And that's it.
Did you have any specific comments on Mr. Davis's rebuttal?
So I did review Mr. Davis's rebuttal. My main comment around that was noting that the other facilities that are proposed to be zoned mixed use are often very large, kind of regional or local facilities, and that they're the Huia Pool, the Walter Nash Stadium. They're not essentially what is a small park with a few community facilities located on it. So there's quite a difference in scale between what has been suggested there, and to a point I'd probably have a view that is still the mixed use the right zone for those, though noting, again, the submission doesn't go there, so really just focusing on is the community, from my view, is the community, for the Moera Reserve, is the, community facility the right, is the mixed use zone the right zone, and given it's set up in the district plan, it's quite a pro-development zone versus what maybe the other recreational zones is. My view is it's probably pushing a bit too hard in terms of how that facility is being used or is to be used in the future.
It's also got a Reserves Act classification.
That is correct.
As well.
Yeah.
But for, what was it, community buildings or something like that?
Community facilities or community buildings, it was definitely that was a Reserve Act classification.
And so is there a reserves management plan that applies to the site at all?
Not a site-specific reserve management plan. It comes under a broader reserve management plan that sits within Hutt City that kind of encompasses a number of different parks.
Yeah, okay. Have you, do you think its Reserves Act classification is relevant to what we're considering at all, or is it just an additional piece of the jigsaw?
For my perspective, it forms a piece of the jigsaw in that it has a reserve use and it's intended to be used for reserve, albeit for community facilities. But when my typical experience has been when you've sought to do full district plan reviews and you've sought a zoning, when there has been facilities like parks or got a reserve classification, often they've had a recreational zone associated with them. It's unusual to see a mixed use zone sit over a piece of land with a reserve classification. So on that view, that was kind of what drove my thought process, that it's not usual you see a pro-development zone align with something that's going to butt up against a reserve classification restriction. All of a sudden the title, the restriction and the zoning are not talking to each other very well. Normally they're more aligned in terms of their purpose, though noting to remove the Reserve Act status, it would have to go through a process anyway.
Thank you. Just hand over to my colleagues.
Thank you, Mr. Bevan. The answers have actually addressed a lot of my concerns that I noted down yesterday when we heard from Mr. Davis on this. Couple of things, starting from the top. Your client is the tenant of the building?
Yeah, so we're in the process of, so we own one of the buildings on the property. So there's a
Your client owns one of
The client, well, it's not my client, I'm talking as the community.
Okay.
Yeah, so there is no, I'm presenting expert evidence for the community house.
Okay.
So they, as the community house, we own the cottage, which is a small building to the rear of, there's a hall, then there's the house, and then there's the cottage to the rear, to the north of it. We are currently going through a divestment process with the council to take on the ownership of the house as well.
And what about the hall?
The hall was owned by Hutt City Council and is intended to be stayed
Yeah, so
retention by Hutt City
it's
Council.
not part of the divestment.
That is not part of the divestment. We have actively explored that with the council, but they have no intent to divest that at this stage.
Yes. Very briefly, how would you categorise the activities that are undertaken?
In the community house?
Yes.
So there's a range of activities. So we do, there can be classes like, there's a little bit of cultural classes that are undertaken there. So cultural groups do hire out the facility. We also have further education provided within there. So for an example, that is we're currently doing Maori language courses in that space. It's used by other charities. So Hapu Mamas is a group that knits for socially deprived houses and provides knitting to them and clothes to babies. It's used by sometimes just the general public as a higher-end facility. So it's got a range of different uses through it. Most of them are very low-key. We're talking no more than 5 to 10 people at a time.
So it's not used for 21st or above visitors or?
No, so people can't stay there. We don't hire it out to parties. It's not used for that facility, that use at all. It's very much tied around community uses or something that advances the community in some way, shape or form.
Sure. And you're satisfied that the sport and active zone zoning would accommodate the current and any future activities?
Yeah, I am, in terms of the intent of what we provide and and where we're going to go. Like, there's no great plans for expansion of activities or changes of building form or anything like that in terms of the buildings we have.
What about for the hall and the house, the cottage then?
The cottage, definitely not. That's another building we own. The hall, we're not aware of any, aside from maintenance work, and when we look at the long-term plan for that, there's nothing signalled within the next 10 years for any works there.
Yeah. What I'm trying to get to, Mr. Bevan, is whether in trying to have a zoning that accommodates the activities that are undertaken in the cottage, are we leaving any sort of orphan authorisations for the activities that are undertaken in the other buildings?
Cool. Yep, no, that's understandable. So in terms of the community hall, the activities that I understand occur there are very similar to what occur in the house, albeit on a larger scale. So they do have cultural activities. It is hired out. The difference is they do hire it out for birthday parties or celebrationary events, which is the point of difference that we do. But again, it probably has overall, from what I see, a lower usage than what the community house generally does.
Okay, sorry, I probably conflated my terms. I think I talked to you about the cottage when I should have been talking about the house, but
yeah.
So what about the cottage itself? What sort of activities are?
So what is the cottage currently used for? So that is used, again, to provide skills. It's hired by an educational facility at the moment, periodically, to provide skills, up training for people that may have been released for prison or have been on the benefit for long term. Okay. They're in there during the week, but previously we've had, again, similar, we've just relocated some activities out of there recently into the house to accommodate some more of that.
Okay. Again, the same question in terms of the activities undertaken on the buildings that you don't currently own or haven't been divested to you. Are you confident that the proposed zoning would accommodate and cater for those activities? I noticed that, note that the community hall obviously, possibly it's hired out for groups, for parties and events, may or may not involve alcohol.
Yes, I guess, given that community facilities in the sport and active recreation zone are permitted, then yes. The one thing I couldn't answer on the spot here is the hours of operation, because I'm not aware of the hours that the community hall is available to, noting that the permitted activity standards have got a 7 a.m. till 10 p.m. time limit. So I'm not aware of the community hall. I mean, I've lived in the community for 13 years and I'm not aware of it ever being used after 10 p.m. But then in saying that, I don't know what Hutt City Council's booking for priorities and limitations they may provide around that.
Are you aware of any consents that are in place for the community hall?
I'm not aware of any at this stage, no.
Okay. What is it about the proposed zoning and the proposed plan that troubles you from a planning point of view in terms of the appropriateness test under section 32?
I guess when I look back, from my perspective, is when you look back at what the objectives in the mixed-use zone is set up for, objective 1 is pretty clear that it's for medium to high-density residential and commercial development, kind of sitting at the end there. So when you're looking at the appropriateness of the zone, given that's unlikely to ever be achieved on this site, given its current use, there's been recent investment in there and there's future investment in there, then is this the most appropriate zone for this piece of land, given how the mixed-use objectives are kind of lined up and what they're seeking to see?
Have you done the same activity same exercise in terms of what the objectives of the sport and active recreation zone objectives are, and whether they align with the activities currently undertaken?
Yes, but not perfectly. So it's more aligned, and that's where I go back to my evidence around the open space zone as well. It's not a perfect alignment, but it does have a more of a put towards playing fields, playgrounds or large playgrounds and community facilities. So it is more directed down what is actually there than more of a pro development enabling future use kind of situation.
Yes. Are community facilities enabled in the mixed use zone?
They are a permitted activity, yes, in the mixed use zone.
It's obviously subject to standards, and you're telling us that the same applies in the sport and active recreation zone, but are the standards any different between the two zone options?
The minimum floor levels is different. Bear with me 1 second.
Floor areas, you mean?
Floor areas before they need consent. I feel like it's 200 square metres in the, 200 square metres in the mixed use zone, and I feel that's 100 square metres in the sports and active recreational zone.
And that's a standard that the house could comply with.
Yes, so in my evidence, I had a review of the different building sizes, and there were I believe two that didn't comply and 2 that would comply.
Okay.
I'd have to, yeah.
Okay, so just to recap, in terms of from an appropriateness point of view, is it your position that the alignment with the sports and active zone is, whilst not perfect, is more appropriate than the mixed use zone? Is that?
That is my view, yes.
Finally, have you had any discussion with the landowner regarding the submission and their position on it in relation, and that being Hutt City Council?
No, not personally, I have not.
Okay. They haven't lodged any further submission in support or opposition to
not that I'm aware
the
of.
community trust?
No.
Okay. Thank you, Mr. Beavan.
Good afternoon, Mr. Beavan. Welcome. Thank you for your statement. Commissioner McMahon has asked most of the questions I intended to, but I guess I just wanted to pick up on one part of your statement at paragraph 5.8. And I fully understand your position about the 2 options that you've considered not necessarily being perfectly suited to the site. And I understand from Mr. Davis that he feels the same. And one of the questions I asked Mr. Davis yesterday is whether he turned his mind to any other alternatives. For example, use of a precinct. And the reason why I was prompted to consider that is because there is an existing precinct in the sports and active recreation zone for the Hutt Park accommodation precinct.
Mm-hmm.
So I just wondered whether you turned your mind to a mechanism like that, which might afford a better fit within the wider context of the zone?
In all honesty, no. I wasn't actually involved in the drafting of the submission on this matter. I was down in West Coast on hearings at that time. And so I limited my evidence purely to what was kind of the scope of the submission point.
Yeah.
Would a precinct work? Potentially, but I haven't given it any strong consideration up to that question.
I'm not sure if you would be limited by scope if you've sought the change to the zone. So it's potentially a method within scope of the zone provisions as they exist.
Yeah.
I'm tempted to ask you if you want to reflect on it and come back to us.
I'm more than happy to, and happy to come back and provide a response to that. That would be.
Could you do that by next week, say?
Yep, easily.
Okay.
You just give me a time when you need it by.
Thursday next week, Friday next week? Yeah, great.
Easy. Yep.
Thank you.
Yep.
That'd be helpful. Thank you, Mr. Beaver.
Thank you.
Hey, Mr. Bevan. Size, nature, scale of the site and the uses and activities, how does it compare to other similar sites in the city and their zoning?
Yeah. So when I looked at how other sites have been zoned through in terms of parks, pocket parks and the likes of that, most do have an open space zone, and that's why I reference that within my evidence. It's kind of noticing most facilities around this size do have it, but there are other parks within the Hutt Valley, and I think Te Whiti Park was an example of it, where it does have a, while that has got playing fields and is a larger facility, it does also have quite a reasonable community facility use on it through the marae and other facilities in the buildings. So I was merely picking up, I think what's driven this submission, if I was to surmise what's got there, is the community facilities that recognises that this park has, the Māori one does have of those, so pulling in that kind of bit of the objective. But if you looked at consistency across the plan, it would be an open space zone.
Just one follow-up question, probably one I should have asked from the outset. You presumably operate under a lease from the council?
Yes, that is correct.
Okay, and that's renewed how often, do you know?
It's historically been reviewed on, it's been a multi-year basis. Last renewal was for a 12-month basis while they go through a change in, we've been going through a change in how they manage facilities on their reserve land. And that is why we're now going through a divestment process, because council doesn't want to take on the ownership, the maintenance of the house anymore. So while they've sorted that out, going through a divestment process, but there's been no conversation of moving any of these facilities off that process in the long term, and quite contrary, we have to show that we can maintain the house for 10 years before it will be divested to us.
And is there any conditions attached to the lease apart from what you've just been referring to?
The conditions...
In terms of like use, what it can and can't be used for?
Basically, I have to turn my mind to the lease. There is, with the divestment process at least, that there's an expected it will remain available for community use and community facilities. It can't be used for commercial purposes. I couldn't talk to what the current lease says off the top of my head, but I'm happy when I come back on the precinct aspect to give a little response around if there's any controls under the current lease.
Oh, that will be helpful. Oh, thank you, Mr. Bevan.
Thank you.
No further questions.
Cool, thank you. Awesome. And I have nothing further, so thank you for your time.
Thank you.
Yes.
We're now at the point of returning back to the 42A report on the industrial zones. After having a discussion with my fellow commissioners, we don't think there's much utility in talking about the Seaview Marina zone, which, okay, but I think we should continue on through the three other primary zones within that report. And I've just got it here, we're up to paragraph 198
That's what I had.
And again, in a similar format to what we were using yesterday with the page turn. Just make sure everybody's... Right, so LIZP 12. Right, GIZP 2.
I have a question there. Paragraph 216, looks like you're recommending an amendment to GIZP 2. I didn't see that in the track change version of your attachment of the provisions. So it's just really a flag if you are recommending an amendment there. If that could be included with your final version of provisions.
Sure, I'll take a note of that.
Well, I'm sorry, you didn't have a response.
Sorry?
You just took that on board, did you? Or
Sorry, I might have got lost there. We talked about
yeah.
Commissioner Muspratt's point. I've made a note of that.
Oh, so that's, okay, we can move on. All right, that's all good. I was sort of expecting, oh, okay, yep, okay, we'll look at that.
No,
Anyway.
I'll make a recommendation there.
No,
There is
no,
nothing in
that's
that,
all right.
in the track changes, so I'll.
Right,
something like
I make it, we're at 224 GIZP 3. GIZP 4. Just one extremely minor comment from me. You use the word chasseur of the policy.
Oh, yeah?
It's normally chapeau.
Well, chapeau's at the top and chasseurs at the bottom.
Oh, was it? I googled chasseur and it came up as being footwear in French.
Well, the chapeau is a hat, so chasseur is shoes.
Okay, I've learned something. Thank you. Move on.
Sorry? Yep.
Right, okay. So I'm at 232. GIZP 5, 238. Now, I've just on your 239 about the submission raises an issue that's potentially relevant to all zones. This formula for the existing activities policy, and it could be misinterpreted. I just had a question. When might this be used in other parts of the plan?
The zones generally have a policy around existing activities, which follows one of two formulations. In the heavy industrial zone, city centre zone and metropolitan centre zone, that policy is trying to encourage that existing activities that are incompatible with that zone be redeveloped. And in the other zones, it takes a more tolerant approach to existing activities and seeks to just sort of manage them generally in accordance with their surroundings. So every zone uses one of the two identical wordings.
Okay. So it's in no way meant to replace anything in the RMA to do with existing use rights then?
No, it would be about when a resource consent is required for an existing activity because it's, you know, upgrading or developing in some way or its
Yeah.
effects have changed. And then what weight should you put on the fact that it already exists in some form in that environment?
So it's, yeah, it's all being part of the existing environment as the existing activities. Okay, I've got you. All right. GIZ P6. P7. P9. P10. And we'll wait all the way down to HIZ P3 at 271. HIZ P5, role and network of community and commercial and industrial areas. And at 277, you say, I disagree with the contention that this matter is irrelevant, that a land use activity may have nowhere else to go. And then you go on to say, I do not think the council has an interest in providing for non-industrial uses in the zone for exactly the same reason that the zone exists for heavy industrial activities. So do you think there is sufficient recognition in there in terms of the primacy of that heavy industrial zone in the Wellington regional context?
Being
the only one that there is?
I'm not aware of the heavy industrial zone national planning standards term being used elsewhere in the district. The RPS is about regional employment locations. It's not specific to industrial areas and it doesn't call out any particular areas by name. So I don't think I would take a position on whether it's the only one in the region, whether, for example, Elsdon, Porirua, or industrial areas, you know, in the Kapiti Coast or near Masterton, for example, would come under that. I think that would be a question of those councils.
In the Wairarapa, I think Wainawa is a heavy industrial zone, but this side of the Rimutakas, certainly Kapiti, just one zone, Wellington, one zone, Porirua, one zone, being a GIZ.
Yeah, I mean, I'm not familiar with the reasoning they all used for the number of zones they used, or whether we could, or what to read into whether they used one or multiple industrial zones for how they see the role of their industrial areas compared to Seaview.
Okay, well, thank you for that. Just, it's, yeah, to me it was, we keep on being told how important Seaview is, and it's, you know, it's hugely important as the only real area where certain things such as the fuel tanks can actually go. All right, we'll move on. P6. P8. HIZ P9. And then we're on to the rules. Okay? LIZR3. You've, at 302, where the energy companies or the Z Energy and the fuel companies, they're requesting an exemption for service stations. And you don't think there's a sound policy basis for exempting service stations, considering we're in the industrial zones here.
Sorry, go on.
Sorry, go ahead.
I thought you had more to.
I guess the question being, I have seen plans where there is an exemption for service stations because they are sort of a different sort of land use to, particularly in commercial zones. But that's certainly not the blanket approach. But you've explained further why you don't think that service stations are required to be exempted, or getting special treatment within the zone.
Yeah, so I mean, this is quite a different situation, I guess, to the commercial zones where the submitter's concerns were that the standards themselves, service stations wouldn't be compatible with them. For the light industrial zone, these standards are designed with things like service stations in mind. I think the bigger question is about whether there's an existing non-compliance, how practical it is to apply that. And so I believe that's discussed in terms of the landscaping and screening standard and the industrial main through route frontage overlay. We're recommend accepting relief from, I can't remember off the top of my head which submitter, but that compliance with that standard only be required where there's a new building rather than additions and alterations. That would be the main one I'd think would be a practical issue for service stations, and I think for a new service station it should be able to meet that standard. Other than that, I think the standards, overlooking setbacks, height in relation to boundary and height, things that I think are issues for service stations as much for other types of industrial activities.
Yeah, transportation issues as well, normally, in terms of site visibility and that sort of thing. Particularly because they need much bigger crossings and sort of thing too.
Those issues have their own standards in the transportation chapter.
Yeah.
Just on that. I was a little bit confused on this morning, so that's why I sought some clarification from Ms McPherson. And rereading her 42 her evidence in chief, and it's a shame she didn't provide any rebuttal on the matter, but I understood that she was drawing a distinction between new service stations and major expansions or redevelopment of existing, and minor additions and alterations, which may include new buildings on existing.
Yeah.
Does LIZR3 endeavour or attempt to deal with those two different situations? Because Ms McPherson was saying she wasn't pursuing some of the other relief in their submission on the basis that this sort of rule was modified to exempt service stations.
I'd probably have to go back and check her most recent evidence to see which provisions and which zones she was talking about for that point.
It was primarily the metropolitan and city centre, but she did mention the light industrial zones also.
Yeah, so the industrial zones have quite a different framework to the city centre and metro centre zones, in that the city centre and metro centre require resource consent for most development and redevelopment as a buildings and structures rules. The light industrial zone, like most of the zones in the plan, provide for buildings and structures to be permitted as long as they meet the performance standards in the zone.
Yes.
And then you would take a standard approach to existing non-compliances, as with any zone. So I would kind of see that point of hers as being more relevant to the city centre and metro centre zones.
For the rules on new buildings, alterations and additions, the submission was in relation to the MCZ, the CCZ and the LCZ.
Oh, LCZ?
Sorry. LIZ, I think, sorry.
Okay, I might need to read more of that and come back to you because I think there were points about, from other submitters as well, about how that applied in the LCZ, and so I want to double check.
Okay, there may be a transcription error by me then. Okay. Okay. If you could clarify that, that would be useful. Yep.
At 304, you've got your last sentence of 304 says, in general, buildings are longer lasting than land uses and have a longer term effect on industrial development capacity.
Yep.
Is that always true? Because normally, if you're looking at a change of land use, you would also look at the form of the buildings which are on the property at the time, and whether they are fit for form and function for the alternative land use.
You mean the tenant would look at the buildings?
Sorry, speak up.
You mean the tenant, with the prospective tenant would look at the buildings? And
Yeah,
decide?
they'd look at the buildings to see whether they are going to suit their purposes and potentially redevelop them if they don't.
Yeah, and so I think sometimes they would and sometimes they wouldn't, and also often they would be looking for existing buildings that already suit their needs or need fewer modifications. I think in a commercial environment it is, you do see, tenants come and go from sites without substantially redeveloping the building, doing a new fit out maybe, or, minor changes to yard areas, but not knocking down the building and building something new. The issue that the plan's trying to manage with this is a building that might be quite specialised to a land use, especially something like residential.
Or a service station.
Or a service station, although that's anticipated in the zone, so
yeah,
wouldn't be managed as such. But you've got a lot of sunk capital in a building that's quite specific to a particular land use, and then it wouldn't be suitable for general industrial tenants in the future. But because there's that big sunk investment, it's unlikely to go back to industrial use.
Now, I guess I can see both sides of that as well. All right, we'll move on. GIZR3 at 313. HIZR3. And then to the rules for land use activities. At 18. Oh, no, I'm at LIZR 18, residential activities. You got a question?
LIZR 18. So Z Energy are raising an issue here that I'm wondering if it comes down to the use of the word ancillary in the rule, but not using the defined term ancillary activity. So they're pointing out 50% would not be subsidiary in terms of the definition for ancillary activity. So my question is, does the use of the term ancillary, is it meant to be ancillary activity in terms of the defined term, or is it another word? Get rid of that confusion.
I'll probably have to go and have a look at that definition in a bit more detail to.
Yeah, I think
answer
what they're getting, I think it's a maths issue. They're saying, well, if it's supposed to be subsidiary, then 50% is actually not subsidiary. But then it comes down to what the defined term is.
Yeah.
Thank you.
An issue at 330, and we sort of talked about this a little yesterday as well, about the 50% threshold. And LIZR 18 for residential. Now that's 50% of the site, isn't it? So it could be that if it's a small site, then 50% could be used or theoretically used, subject to other matters, obviously, for residential. Just wondering why 50% was chosen. Do you got any background to that metric?
One of the council's goals in this approach was to provide for live-work units.
Yeah.
the idea is to leave it open to a resource consent assessment about what exactly ancillary would be, because it is still an RD entry point, even if you meet the conditions. It was looking at sort of existing live work units that have been proposed or, exist in other cities, which tended to have a roughly equal split between the sort of workshop area and the residential part.
Do you know how much demand there's been for live work arrangements? There's not too many of them around that I'm familiar with anyway.
Yeah, we certainly see them proposed fairly regularly in industrial areas. The question for the council is how much is that genuinely trying to meet an industrial demand, a demand for live work units versus sort of seeing the industrial part of it as a loss leader to just get a residential unit in the light industrial zone. I think it is a balanced issue, but again, you are still going straight into restricted discretionary consent that gets to look at some of these issues, including investigating how genuine the industrial component of the activity is.
Okay. All right. LIZR 19. GIZR 8. GIZR 10, grocery stores and supermarkets. I guess with that, and again, we talked about supermarkets yesterday, is whether or not it gives the wrong signals in terms of protecting the industrial base and whether it's supermarket is serving a catchment, particularly residential catchment. I think the same applies here. But it is an RDA, so they would have to prove it. There's a test in there to prove that they need to be there.
Yeah.
I'm down to GIZ R14.
GIZ R14, I've just seen it also has that use of that term ancillary, so I'd suggest that needs to be looked at across the plan, but that's not my question. So EnviroNZ is seeking the addition of on the same site.
Yeah.
And I have seen elsewhere examples where someone would say, well, here's the activity over on this site. The ancillary activity is over on this site, but it's ancillary to that. And I'm just wondering if there is actually value in saying on the same site, just to confirm that the ancillary is on the same site, or is this another example of where if you were to use the defined term ancillary activity, it would fix that?
Yeah, I'll have another look at that definition of ancillary activity to see what would be the issue there. I mean, obviously there's a bit of a different context than the residential because it's a permitted activity condition, not a, well, it is still a rule condition, but it would mean the difference between a permitted activity and a resource consent.
Is it supposed to be limited to the same activity, ancillary activity on the same site to an industrial activity?
I mean, it's been supposed to be in the same place. The plan steers away from using the word site unless it has to, because it has quite a specific definition about the structure of, the way that land is owned. I think it's less of an issue in industrial areas where it tends to line up more with who's doing what, and more of an issue in commercial and especially open space areas where often the sites are extremely weird.
Okay.
Right. GIZR 17, 361. GIZR 18, heavy industrial activities. No, it was previous one, GIZR 17.
Yeah. Right, you have to bear with me on this one. I'm just wondering if GIZR 17, is this a circular rule in terms of, let me see if I can get this out.
Any activity not otherwise provided for is a permitted activity if it's ancillary to a permitted activity, which would fall under this. So yeah, should the standard link back to the specifically listed permitted activities within the zone that are specifically listed in the rules rather than just permitted activity? Otherwise, I think it might just link back to this rule again. The standard.
Yeah, sure. I think the issue that that's trying to address is just that some definitions of activities include ancillary activities and some don't.
But if it said the activity is ancillary to a permitted activity under the rules in the GIZ chapter, would that make it clearer that it's not just a circular loop back to this rule?
Sorry, what was that wording you used?
The wording was pretty rough, but basically if the standard was to say that the activity is ancillary to a permitted activity under the GIZ rules, so a specifically listed permitted activity rather than this catch-all rule.
Sure, I can have a look at that.
Thank you.
Right. Where were we at? Sorry. GIZ 17, 18, 20, 22, then went to HIZ rules, heavy industrial activities. General rules, LIZ, R23, outdoor storage. LIZ R24. Outdoor storage, R23.
Good afternoon, Mr. Davis. I'm looking at paragraph 384. This is a plan coherence question related to a question I asked of you yesterday. And here, in this context of outdoor storage, you've qualified the visibility of the outdoor storage space based on being a level view. And if you remember yesterday, I asked you about minor buildings.
Yep.
Do you think there's any merit in considering those in a similar way?
How do you, your relation to your point about minor buildings in relation to the height limit, or?
No, so the question I put to you yesterday related to the visibility of minor buildings, and,
Sure.
the visibility was from any public space, and I gave the example of a CCZ minor building, or sorry, a MCZ minor building being viewed from Korokoro. I'm just putting a similar principle to you here. Is there a potential relationship between the two in effects terms?
Yes, I think this is a performance standard in a sense, and I think there are a lot of circumstances where it's going to be not achievable in a way that's practical relative to the benefits of screening it, and industrial yards, people are going to see them when they're up on the hills. For the Seaview, they're going to see them up in Point Howard. For Korokoro, they're going to see them from up on the hill in Korokoro, and so on. There's no realistic way that standard could be achieved if it applied to those. For the Metro Centre zone, it is a trigger for assessment against urban design principles. I don't know if it's necessarily going to be a major effect of any building as seen from Korokoro, how it applies to, say, the Jackson Street character transition precinct or something. But I don't know what other sort of line you would draw about distance from the site. Certainly within the scope of what people have asked for, that would be, we'd be happy that's making much of a difference.
do you think the addition of at-level view or a similarly framed concept in the right context might be a start?
Yes, I have to have a think about that. What another difference is, that rule for buildings and structures, those are potentially above ground level, those additions and alterations or minor buildings, whereas the yard itself would be at ground level. I don't think that's a deal breaker. It's something I probably need to think a bit more about how that difference would play out.
Yeah, that'd be useful. I'm thinking about it in the context of the definition that you've proposed as well, which would limit them to the height of the ceiling, basically, which is, double the height of a fence screening an outdoor storage area. Thank you.
So I think we're on LIZ R24 servicing. Page 85. Down to the rules, new rules sort. Jason?
I'm just looking at the discussion you have at pairs 412 through 417 about wholesalers. And you might have heard my questions of Ms. Wareham yesterday about the possibility of a wholesaler or activity of that nature being captured by the general activity rule R16.
Yep.
And if that proposal was mooted and it was over 500 square meters, it would fall as a non-complying activity. Would that be your expectation as well?
Yeah, I flagged that during evidence as well. I think there's interaction with how the rules that might capture a wholesaler would otherwise apply when they don't meet the standards, so trade, supply, retail, and
yes,
supermarkets, which do differ across the zones. And I think there may be some tidying up that needs to be done there to be consistent about what happens when they don't meet those standards. Because I think the issue I'm worried about is that you would end up with a more onerous status for a wholesaler that happened to not fall within the definition of trade, supply, retail, than one that merely failed the conditions.
That's precisely what I was seeing into that as well. So I do think there's probably cause to tidy that up in some way.
Yeah. I think that issue is probably not specific to wholesalers, but
Yeah,
needs
that's
to
right.
be addressed.
It's possibly a reason to reflect on that non-complying activity default, particularly compared to, I don't have the zone rule in front of me. Bear with me 1 second. Yeah, the other activities not otherwise provided for under R17 defaults to discretionary, whereas the commercial activities not otherwise provided for defaults to non-complying. So that's just a coherence thing to maybe reflect on.
Yeah, I'm going to have a think about that. The key reason for the non-complying status would be for activities that seriously threaten the centre's hierarchy rather than failure of standards.
Yes. And that would link back to the protectionist policies around the commercial centres. Yeah, okay.
Yeah.
Thank you.
And then we're on to standards. 419. Setbacks, landscaping and screening. GIZS 5, landscaping and screening. And then new standard sort, firefighting, water supply. some zone maps. Victoria Streets. Sure. And Mr. Cummings' evidence yesterday as
Yes,
well.
yes. Just on Mr. Cummings' evidence, I asked him the question yesterday about the built form outcomes anticipated in the two zones that are at play here. Just wondering whether you've thought about that question I put to Mr. Cumming about the interface with the reserve and I guess with the back of the school.
Yeah.
And whether we might expect a better built form outcome addressing those spaces under one of the zones rather than another?
Both zones have sort of general policies about how they interface with zones that aren't of their own category, which principally are sort of recession plane based and then triggers for assessment under various circumstances. For this site's case, I think the school is built in a way that kind of anticipates something on the site that is not something one wants to necessarily see, and so it sort of has, I think, I've only looked at the aerials, haven't been onto the site, but like groundskeeping facilities and buildings hard up on the boundary that would screen it from the view of pupils. And then for the reserve, this boundary is used for the car park for the reserve. So the existing land use, I think, both of those sites sort of anticipate that this site is going to be used for something that it may need an interface with. Those uses could both change. That school as a designation, and that the open space zone for reserve allows it to be reconfigured at any time. But that's the existing situation. I mean, they're both aware that they border an existing car yard which has been there for some years.
Just while we're on that, and I should have asked Mr. Cummings this yesterday, just having a look at the aerial photograph of the site, and there's a largish white building which is to the rear of the site. Do you know what that is? Short of going and having a look ourselves.
Whereabouts you look? I mean, I have the same area
So
as you.
105 to 107 Victoria Street, and you've got Art Central School right at the back, or the buildings are right, some distance away. But then immediately behind the site, there's a white building, a white roofed building anyway.
On the school's site?
Yeah, it looks like it's on the school site.
If you give me a second, I'll pull up.
It's not of huge import. I was just curious when I just brought up the aerial, having a look. Looks like a kindergarten building or something like that.
Yeah, I mean, I only know what I can see from the aerials. I haven't done a site visit of that.
We can find that out. In fact, there's on Google Maps, there's a Allistown Play Centre.
Yeah.
It's popped up, which is not on top of that building, but it looks like it's the entrance to it. Anyway, we should move on. ODP Avalon Business Activity Area. Right, overlay and specific control maps. Industrial main through route frontage overlay. And then we're into the Seaview Marina Zone. And Commissioner Jones just passed me a note saying he's got some questions on this outside of what's been talked about this morning, which he'd like to put to you. Yeah, sure. okay. Matt, you've got one thing.
Oh, yeah. Just for your benefit, Mr. Davis, it's not really a question, but if I look at your recommended changes to SMZ R23, I'm just wondering if the standard, I'll wait for you to catch up,
Sure, yeah, and that R23.
is supposed to be referring to activities sensitive to industry rather than residential. So just the standard, if it's referring to the wrong activity there, because the rule is activities sensitive to industry other than residential, and the standard is talking about residential.
Yes.
Yeah. So if there's a typo,
I'm sure that error looks familiar.
Yeah.
Check whether I might have done it in the rebuttal or
okay.
not.
I just thought I'd raise it heading into conferencing, just knowing. But you may well have already addressed that, so apologies if you have.
I might have spotted the equivalent somewhere else. I mean, a lot of copying and pasting that goes into preparing a plan. I've certainly seen that somewhere, so I'll have a look and see how consistent it is. The CV Marina Zone was for context, was a precinct in the general industrial zone in the draft plan, and so as notified, it largely carries over provisions taken from the general industrial zone and then modified to suit the feedback we had on the draft.
So was it precinct in the draft plan or the operative plan?
Sorry, in the draft plan.
And what was it in the operative plan?
It's a special recreation activity area. There are, I think, 3 special recreation activity areas, each of which is essentially a completely different zone. So,
yeah. Okay, thank you. Your 2 questions? Or
First question is at paragraph 601.
sorry, 601?
601, yeah. And this relates to Rule 3.
Right, yes.
And Clause B under the permitted activity rule, which requires the building structure alteration or addition to be for the purpose of an activity permitted by one or more of the rules for the land use activities.
Yes.
Are there any other chapters in the plan that use that structure?
Yes, that's the standard structure for the industrial zones.
Yep.
Looking at that, this immediately leaps out as another issue caused by how the zone started its life. The key purpose of that rule is for the assessment of buildings for their impact on industrial development capacity, which isn't relevant to this zone.
Thank you. And it's only in the industrial zones where that approach is adopted?
That I'm aware of, yes.
And the other point is down where you discuss the definition of marina activities. I think perhaps in the context of SMZ R19, so I'm looking at paragraph 643.
Sure. Yep.
And you note there that the rules in the chapter as proposed already provide a wide, fairly range of potentially ancillary activities, either within the recommended definition of marine activities or in other permitted rules. And my question is, with the mechanics of the changes you've recommended to the definition of marina, which includes an ancillary activity, and then at Rule 19, which limits commercial activities where ancillary to marine activity, that seems to be in conflict.
Sorry, what rule reference was that again?
So at Rule R19,
at that.
You've talked about ancillary activities to marina activities. The discretionary clause is subclause 2C. The commercial activity is ancillary to marina activities. But the definition of marina activities includes ancillary. Is that a circular construction?
Yeah, I'll have to have a look at that.
Yes? So you can turn your mind to that? Thank you.
Thank you. I'm just going through my own notes about anything we haven't really talked about. We talked about the breakwaters. Yeah, just while we're talking about breakwaters, I just have one thing highlighted. 704. We talk about breakwaters to remain in the open space zone or avoid a split zoning, etc. You talked about it will still be controlled by council operationally and or subject to Reserves Act restrictions. Do you know whether there's any Reserves Act restrictions?
It's currently part of the reserve. It's the same reserve as the Seaview Beach.
Yeah.
I'm not aware of what the reserve management plan is, and I don't think it's clear from the marina whether they're taking on the breakwaters from the council would also involve lifting the reserve status or leaving it as is. So,
is there an intention that there be public access? Do you know offhand? It could have been a question for the marina people.
There is certainly public access at the moment. I don't know of any intention to change that. The marina itself also has conditions around public access as part of its original consent to do the reclamation.
So people go and fish off it, do they, and things like that? Okay. Right, then we're on to definitions. That's at page 153. Yeah, it's right up to what we were talking about this morning. Sorry, I'm just thinking out loud. Activity sensitive to industry has some correlation with what we were talking about this morning. Right, I don't have anything further. Can we have 5 minutes just to go and have a wee chat? There's one additional thing that we need to clarify as well.
Sure.
But if we can just adjourn for 5 minutes and then come back shortly. Okay, we've been having a bit of a talk about next steps.
Yep.
There's the matter of Seaview hazardous substances, which we've exhausted, and we're going to direct conferencing. So that's quite a discrete matter.
Yep.
And I think that's been pretty well telegraphed. We'll be also preparing a more detailed minute on a number of different aspects which have arisen.
Yep.
That includes also for you to have a time to consider a response to what Ms. Allen and Ms. Skilton said yesterday, particularly in relation to the MUZ zoning, Cuba Street, Britannia Street. They were the ones which were raised. So we're going to be looking at some specific comment on those from you. Other matters which have been highlighted at the moment, and there will be others, but this is just front of mind, is the active frontage controls, the standards that relate to them, the complexity of them, whether they could be shortened, amended within scope.
Yep.
Okay. Was there anything else in terms of preliminary? I think with the community house, I think we've possibly got enough noticing that the submitter's coming back to us next week with some additional further information. But other than that, we need to sit down and go through this fairly systematically. It's only been 2 days, but it's actually been packed in a lot of stuff. Last 2 days.
A lot of material being lodged.
Yeah, there's been a lot of material. Your own Section 42A reports and rebuttal have been lengthy as well, and with some not straightforward issues either at times. And then there's obviously the issue of reverse sensitivity. So, and we will do that as quickly as we can. We ourselves have a few combined timing issues ourselves, which we'll try and work around, but we will communicate formally firstly with the minute directing conferencing, and then with the time frame of your formal right of reply and Mr. Wesney's formal right of reply as well, that we have a receipt of that like 2 weeks after the conferencing statement is complete. So it'll give you some idea now of our process looking forward.
Sure.
Anything else to add? Okay. Well, I think we'll.
I just wanted to. Just something would be good to check. You wanted comment on Ms. Skilton's evidence, whether you wanted us to put a transport lens on that and get an expert evidence response to that, or whether you
I think she's going to also have her. She's going to be coming to the transport.
Yeah.
I think the big question is for us is the appropriateness of the zoning in that area, and that has a relationship with Cuba Street in particular, but the same applies to Britannia, which doesn't have the same transport issues that Cuba has, because Cuba has that arterial function. If you think that it would be helpful to us to provide get somebody with a transport lens, we welcome that as well.
Okay. I'll think about that.
Is that fair? Okay, I think we will adjourn for now, and thank you for your time, and thank you for all the effort. There was a pretty big task you've had to look at in the last couple of days.
Thank you.
Are we doing a karakia? Una here, iti. Oh, that's Here we go. Shall we start again? Unahia, unahia, unahia I te uru tapu nui. Kia watea, kia mama. Te nakau, te tinana, te wairua, I te ara takatu. Koea ro tongo, wakarongo, gay,